parties to put their names on the record.
Taylor Fleming on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Chantel Keys, pretrial.
Thank you. Okay, the first case I have is a Spanish case, so let me give the interpreters a call.
Good morning, Your Honor. This is Peresno Leon, certified Spanish interpreter. I have been previously sworn.
Hi, good morning. This is Judge Martha Adams. We're out at the Booking and Release Center at the jail. The first case I have this morning is 2022 MM 8022 AO. The defendant's name is Emmanuel Figueroa Fernandez. And he does have the headset on.
Thank you, Your Honor. The interpreter can confirm there is connection with the headsets.
Okay, thank you. Good morning, sir. Can I just verify that you were born on December 20th of 1989?
Correcto.
That is correct.
So, sir, I have read the charging affidavit in this case. I am finding that there's probable cause to charge you with battery. I will, let's see. It looks like you don't qualify for the services of the public defender. Are you going to be able to hire your own attorney?
No.
No,
Okay. It indicated on your affidavit of insolvency that you get paid every week. Is that correct?
Sí.
yes,
Is that $1,300 amount, is that how much you bring home every week?
No, eso es lo que yo hago manejando para Uber.
no. That's how much I make driving for Uber.
Okay, so you're able to bring home that much money every week from your job, correct?
Limpio, no. Tengo que deducir los gastos y me quedan como 700, 800 a la semana.
No, that is not the net amount. After I deduce all the expenses, I bring approximately between $700 to $800 a week.
And I am correct that you have no children, is that right?
Es correcto.
That is correct.
He still makes too much. The problem, sir, is you still make too much money to qualify for the services of the public defender. What I can do is go ahead and talk to you about getting out of jail, and then you can maybe look into contacting an attorney later if you think you might need one. But my goal today is really just to try to get you out of jail. So I will tell you that I have reviewed your history, and you do qualify for pretrial release. So because of that, I can release you without having to pay a monetary bond. You'll just be supervised by pretrial services. Now, obviously, sir, without your wife here this morning, I have to issue a no contact order between the two of you. That means that you're going to have to find someplace else to live at this time because this no contact order goes into effect right now.
De acuerdo.
I agree.
Okay. So what I will do is, because obviously you can't live with your wife right now, I will allow you to return one time with law enforcement officers so that you can collect some belongings. And I will also order you not to possess any weapons or firearms. So just keep in mind, if you want this order to change, you do need to either hire an attorney and contact Judge McGinnis to get this order to change, or if you want, you can try to contact him on your own with the state attorney's office to see if they will or that you can intervene with him that way. Okay, do you have any questions for me?
No tengo ninguna pregunta. Perfecto. Muchísimas gracias.
I do not have any questions. Everything is perfect. Thank you very much.
Okay, you're very welcome, sir. Good luck to you. Thank you. Okay, that's the only Spanish case I have for today. Thank you.
Thank you very much, Your Honor. You have a wonderful day.
You too. Bye-bye.
Bye-bye.
Next, I have Clarence Jones.
Good morning.
Hi, good morning, Mr. Jones. You're here as an add-on for the violation of probation. You're currently on probation, and with the new law violation that violated that, so there has been a warrant or an arrest made. The bond is set at none. I will go ahead and appoint the Public Defender's Office to represent you, okay? And that's in case number 2020 CF 5296AL.
Excuse me.
Yes, sir.
I was taken off probation.
Oh, did we have this conversation the other day?
Yes, I was taken off probation after being on probation for about 2 years. And I was trespassed, and I was arrested where I was trespassed. I shouldn't be on probation. And you gave me a bond of $250 just yesterday. Why would you take that away?
I'm not taking that away. That bond still exists. What I'm telling you is there's now a new charge because someone, and this is what I said before, is that you may not think that you were on probation, but somebody thought that you were. And so obviously somebody, based on the Department of Corrections website and talking to the Department of Corrections, believes that you're still on probation. So I think the best thing now is to contact your attorney and talk to them and try to get that sorted out. The problem is a violation of probation comes with no bond.
Okay, so I still do have that $250 bond though.
On that case, yes, sir.
Okay, so if I did make bond for that, would I be released?
No, because you now have this one that has no bond.
Okay, I don't understand how they would make that mistake, meaning it should be in the system and it should be in file showing, because I signed a contract, I signed the document, I was in court, I signed actual couple of contracts, and excuse me, and
Mr. Jones, I totally
I was-
understand where you're coming from, and I understand your frustration. I think that Ms. George also,
it's
when we
not
talk-
frustration, it's
well, you're being locked up.
concerned and
I understand that's a
and
frustration.
It's concern and it's curiosity because I don't understand.
If I may,
Huh?
he did admit to a violation of probation prior on the burglary of an occupied dwelling. He did, it looks like there was an admission of the violation at one point. So he was
I violated.
on
I was-
probation, he violated, and he resolved that issue, but it looks like he's on probation for that burglary until March 7th of 2023. So he is still on probation. His last conviction, he did plead to a violation of probation, but that did not terminate the probation from what I can see.
And that's the problem, Mr. Jones, that I think that we were talking about the other day, was that you thought that probation was done, and for whatever reason, what's in the computer shows that you're still on probation until March of next year. So I believe Ms. George had already possibly talked to the PD that was assigned to the new case to see if they could look into that. So now I would tell you to contact directly the information she gave you this morning so that you can talk to that attorney directly and see if they can sort that out for you. Because the only person that can get rid of this warrant is the judge that's in that trial division that, that placed you on probation.
Okay, what? Okay. My public defender, the judge, told me that day when I was at court, possibly a month and a half ago, told me that I am completely off probation after I signed that contract in the courthouse downstairs. They told me that I was done with probation. They told me that I was completely, I forgot the word they used. I believe it started with a R, maybe. No, not a R.
Revoked? They
No, wasn't
revocation?
revoked. But they told me that I was done with probation, okay?
And I'm not
And I
saying.
signed
piece of paper.
No, it wasn't a piece of paper. It was thicker than that.
But Mr. Jones, and I'm not denying that somebody didn't tell you that. What I'm saying is that
I-
there's been some kind of mistake because you
Okay.
think that that's what happened because that's what somebody told you, but somebody didn't go back and fix the paperwork. The only person that can fix that now is the trial judge who originally told you what you're telling me. So the
So where's my suit? Where's my lawsuit? Because if it's their fault that they didn't update that information, how is that my fault? That I'm not receiving the information?
This isn't about anybody's fault. This is about trying to figure this out. The only way I can help you do that is to have you contact your attorney so that they can get you back in front of that judge to do that. Otherwise, I really, there's nothing much more I can do here today. I'm sorry. Okay? Thank you.
Have you messaged Brooke? Have you messaged Brooke?
Okay. Good morning. This is Mario Charles Conti.
Yes, ma'am.
And Mr. Conti, I just want to verify you were born on March 13th of 1984?
Yes, ma'am.
And Mr. Lindsay, you're here on behalf of Mr. Conti for his initial appearance this morning?
Yes, Your Honor, I represent him.
Okay. And this was a warrant that was signed, that looks like Judge Whitehead's signature. Sure whose signature it is, but it
I
was,
couldn't tell whose it was. I thought it might even be a Judge McDonald, retired judge, but I couldn't tell either.
that's quite possible as well.
Tell.
In any case, a judge signed the warrant, so they're the ones that determine probable cause. My only job here today is to determine the bond amount. Obviously, Mr. Lindsay, my concern with this case is that it's kind of been going on for quite some time, and I know how you are with your clients. You usually are very good at explaining things to them and explaining injunctions and no contact orders. So I think maybe it just warrants another conversation, Mr. Conti, with Mr. Lindsay, that you understand the injunction and how that works. Because it's contact is not just something between you and I. It can be done through lots of different methods. And so we really need to stop that. I am going to note that this is case number 2022 CF 132560. It is assigned to Division 17. I will not appoint the public defender since you have Mr. Lindsay. My inclination was to set his bond at $5,000, Mr. Lindsay, unless, oh, and I apologize, I didn't even see you standing there. Ma'am, can you raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay. And ma'am, can I get you to tell me your name?
Stacy Conti?
Okay. And this is your ex-husband, correct?
Correct.
Okay. And Ms. Conti, like I said, I did read through the affidavit that the judge signed, which the officer indicated numerous incidents in violation of this. Was there anything else you wanted to tell me?
It's not that he doesn't understand. He runs a multi-million-dollar company that he owns. He fully understands. He just doesn't care.
Okay.
And he wants to harass me. And he's finding every way that he can. He's finding any kind of loophole he can. He's harassing me through our children because he knows that if I report it, there's nothing that can be done about it. And I just want it to stop.
Mr. Lindsay, was there anything else you wanted to tell
No,
the
Your Honor,
court?
we contested. I know that a circuit judge found probable cause. We contested there was probable cause within the four corners of the affidavit. But, Your Honor, he lives here. He has 3 children he supports. And, we would ask the court for a $1,000 bond with the requirement of no contact with Mrs. Conti.
Okay. Ms. Fleming, was there anything you wanted to say on behalf of the state?
Your Honor, the only thing the state would bring to your attention is, I know you have the criminal history of Mr. Conti, which it appears to be all violations of domestic injunctions. But currently, he has this one that is currently open, the violation of 2 or more. He also has a current misdemeanor non-arrest that's open that has not yet been filed on. The victim also being Miss Stacy Conti. But other than that, he does have 1, 2, 3 other prior, I believe, violations of domestic injunctions. Just it would just bring that to your attention when setting his bond.
Your Honor, we would contest that. There was, the one was actually no billed yesterday or no information yesterday, so.
Your Honor, he was found, pled on the violation of probation and was guilty on that.
Okay. So that was my next question, though. Is he currently on state probation?
He's on probation, which was reinstated yesterday, so this matter would have no effect on probation.
Okay, okay. And,
He's on misdemeanor probation, which was reinstated yesterday, so he has, so anything prior to yesterday doesn't. This is all he has, is this charge pending right now.
that was
When
my
was
only
the
concern, was to just make him aware that this might violate that probation, but based on what you're telling me, this will not, because you took care of it yesterday.
Well,
Because this charge came before him.
before he was reinstated.
Right, right.
When was he off probation?
He was never off probation. What I'm saying is, because he got reinstated to probation yesterday, this charge doesn't necessarily violate that probation. Now, somebody could argue that you could go back and try to do it, but that's a whole legal gymnastics kind of thing that needs to go on. My bigger question is, how old are your children?
6, 8, and 10.
6, 8, and 10? Okay. Mr. Conti, I don't want you to tell me anything about the case. I just want you to know, obviously with children that young, you're going to have to deal with her for a very long time. And you're going to have to find some way to coexist without being so acrimonious, or else, Mr. Lindsay, one, you're going to end up probably buying him a new boat or something, not intentionally, but, and I'm not trying to make light of it, but you're going to continue to get arrested because she's got this injunction. And even if Mr. Lindsay can later on go back and argue that what you did was not in fact a violation, it still every single time triggers you to go to jail. And I would assume, if your ex-wife is correct, if you own a multi-million-dollar business, that's probably not a good look for you. And in the long run, it's really the only thing that's happening is you're ruining your relationship with your children. And that's what I'd really be concerned about. But here's what I'm going to do. I am going to keep the bond set at $5,000. I am going to order that you continue to have no contact with your ex-wife pursuant to the injunction. And all of it entails inside that. So that order is just acknowledging that as part of the conditions of this release, that you'll continue to abide by the injunction. Okay, good luck to both of you. Thank you.
Thank you very much, Judge. Good to see you.
Good to see you too. Thank you. Who's calling me? I just heard something. Okay. Oh, okay. Do you know if she speaks English or Spanish? Hi. Let me,
Good morning. My name is Irina Pasiti Sumsap. I have something to talk to you.
okay. My concern was just that I wasn't sure if I was going to be able to get a Thai interpreter, but you seem to speak English very well.
Okay, thank you. I need to know that for right now, that's what I heard, that he had to be, my husband has to be in the jail right now.
So let me go back. What I did was I did allow him to be released, but because you weren't here, or I didn't think that you were here, I issued a no contact order. Because that's usually what we do on domestic cases, so that we can continue keeping the two of you separated.
Okay.
The only difference would be if you're here and you're wanting something different from that. Did you want him to come home? Did you want to have contact with him, or are you okay with the no contact order?
So the non-contact mean he had to be in the jail or?
No, he can get out.
Oh,
He just
okay.
can't have any contact with you. So like, for
okay.
example, he can come back to your home that you share with him, but only one time with law enforcement officers so that he can get his belongings.
Okay,
Otherwise, he's going to have to find someplace else to stay
okay.
and continue to stay away from you.
For how long? Until the case done?
Until you guys go to court and decide something different with the judge.
Okay, so that's meaning I have to go to the court again, right?
It is possible, yes, ma'am.
And if I said, because I can say like, we don't need to spend that much money to find the lawyer or something to go to the court again or something like that.
So that, I let him out on a pretrial release so that he didn't have to pay any money. And so that shouldn't affect you at all. Now, I don't believe he qualifies for the public defender because he made too much money with his driving with Uber. But there again, you shouldn't be the one necessarily trying to hire an attorney for him.
Okay.
But my biggest question is, are you okay with the no contact order?
Actually, I have to be honest, I need help from him, to pick up kid, and he take care a lot of my kid or something like that. That's why I think about if he can come home.
Well, let me ask you, is there somebody that could intervene between the two of you for purposes of helping with the children and that sort of thing? Like, do you have a mom or a sister or his
No.
mom or sister? Or?
Not at all. So he here by himself. He don't have family here. For me, my mom went back to my country already.
Okay.
And it's always happened that I have to ask someone to pick up my kid. If he cannot, we have to pay a lot for that.
Okay.
And then, so one question, if I say I'm okay to let him go home, I still have to find a lawyer to go to the court or anything?
No, you don't need a lawyer at all. The state attorney's office actually represents the entity that's filing the charges against your husband. You are just a witness for them. So you can contact them, and I'm sure the officer that arrested him gave you a lot of information about Harbor House and victim advocates.
No.
No? Okay. Well, if you contact the state attorney's office, they actually have a victim advocate that works for them internally. But then there's also victim advocates that work for Harbor House. You can stay at Harbor House if you would like, but most importantly, they also have lots of social services that will help you with things. But you don't have to hire an attorney. So if you're concerned about him helping you, and because of that, you want him to come home, the only alternative I have, other than the no contact, would be no hostile contact, which means he would not be able to fight, yell, scream, anything like that. But again, all of it is basically a piece of paper unless you call the police and let them know what's going on.
Okay. So the thing was, I think better he'd come home.
Okay.
That's what and it's never happened. And the thing that happened last night is not he not mean to wanna hit me or something like that. He just stay in this country 3 years, and he don't know that in this country he cannot grab my hand and pull me back to the house like that. The thing was, last night I ran out of the house because I don't like people yell or something like that. It happened for me a long time ago. My mom and my dad always fought, and then it's really loud. I don't like it. When we yell each other, I just ran out of the house, and then I just tried to not talk to him. But the neighbor saw that he pulled my hand inside. That's why. So the thing was, he don't know that in this country he cannot do that.
Well,
Mm-hmm.
hopefully he learned his lesson
Yeah.
by getting arrested.
Mm-hmm.
What I can do, ma'am, is, so I just want to make sure your husband is Emmanuel Figueroa Fernandez,
Yes,
correct?
that's right.
So on that case, 2022 MM 8022AO, I had released him with pretrial release with the no contact order. I'll go ahead and change it so that it's a no hostile contact, and that he can come home, but the conditions are that he not possess any weapons or firearms, and he not have any hostile contact with you. Is that okay?
It's okay.
Okay, thank you.
Thank you so much.
Good luck. Okay.
Your Honor, Mr. Jones's case, I had him brought back up because I did speak with, Ms. Tharp, who actually handled his case, and she did confirm he is not on probation. She was the one that actually handled the, probation. He actually pled on that probation. The state's also reaching out to their ASA to confirm. We were gonna see if we could have him, heard first thing, second session, so we can have, my attorney is willing to appear. I was trying to see if I could get the virtual link so she can appear virtually for the hearing.
If you guys can agree
Mhm.
and it's okay with the judge, I'll do whatever you want. The problem is if she says one thing and the state says another, unless I forget which division this is, it's Division 17, is that Judge?
Navarez, I think.
Who?
Navarez.
Judge Navarro. I mean, I can reach out to Judge Navarro and see what she says. I don't know that she's inclined to remember, and all she's gonna tell me is whatever the state and the PD, unless she has an independent recollection of it. And I don't know, to be quite honest with you, how recent was that? Was she even the judge?
A little over a month ago.
Oh, okay,
December,
so it was
October
definitely her.
24th.
Okay. How about, can we find out first whether the state agrees? Because then if the state agrees, then I just dismiss it because we all agree.
Yep, that's what she's
I
reaching out.
emailed our ASA, obviously I can't call her since I'm in court. In between sessions, I'm gonna call her to see if she has independent recollection. There are some notes in ASA notes that are not completely clear, but I am trying to see if we can all get on the same page.
Okay, so can we
Yeah, the-
call him?
Yeah, I'll recall him, but like I said, the biggest thing is I need some type of an agreement. Otherwise, I've got to get it back in front of Judge Navarro.
Oh,
Okay? Okay, so Mr. Jones, we're going to work on this. Hopefully I'll bring you back in like a couple hours and we'll see what we can figure out, okay? Okay, thanks.
Yeah.
It's gonna be that kind of day. Okay. This is Karina.
Yes, good morning.
Good morning, Karina. I know we saw you yesterday, and Ms. Fleming, I don't know what Ms. Eugene was able to convey, but if you saw the original charging affidavit in 2022 CF 13802AO, it obviously charged her with a first-degree felony punishable by life, but when you get to the affidavit, it's 2 sentences, and it doesn't really back that up. So we were hoping that maybe we could get some more information to find out what the officer's intent was.
Yeah, Sharon, I did obtain a new affidavit from the officer. May I approach?
Yes.
I already have provided the affidavit.
Thank you.
And upon reading it, it seems to be a Berg structure, not a Berg bat. So she would be entitled to a bond. The defendant was not home, or no one was home. It is alleged in the affidavit that she, I believe, broke through the pool screen and then broke a window, got into the house, and then stole a gold chain or bracelet, necklace. However, there was no battery alleged within this affidavit. Therefore, it would just be a Berg structure, which would then entitle Ms. Gomez to bond.
Okay. Okay. Ms. Gomez, does that sound better to you as well?
Yeah.
No, but,
Yeah, it will be cleared at its own time.
okay.
But right now,
The main thing is I just wanted to make sure you understood that based on the way the original charging affidavit was, you weren't entitled to a bond. So now that, even as we have all of the facts, you actually are entitled to a bond. So I can at least get you that. Let me ask you a question, though, and I'm not saying you can't go back to Georgia, but obviously you were, when the police picked you up, you were attempting to go back to Georgia. Is that where you live?
Yeah, that's where I live, actually, that I was heading back home at that time.
Okay. And is it your intent to go back to Atlanta?
Yeah, I was supposed to leave by that day, more in the morning, but I was pretty much kept here for that whole day.
Okay. So here's what I'll do. I will go ahead, I'll set your bond at $5,000. I am gonna order that you have, that you not return to that location. I can imagine that you want to.
No.
That you not have any contact with the alleged victim in this case, which that probably won't be an issue. I do not have a problem with you going back to Georgia. I am gonna appoint the public defender's office, so just stay in contact with them so that they can keep you updated as to what's going on. And I'm also gonna order that you not possess any weapons or firearms, okay?
Okay.
Do you have any questions?
No, I mean, whatever I say, I'll have to clear it out, but pretty much the victim that it stated, he was in custody as well at that moment, at that time with the statement.
Don't tell me anything about the facts. I'm just going off of what's on the four corners of the affidavit, okay?
Okay, that's fine.
Good luck to you, ma'am. Thank you.
And Your Honor, state with us that you find PC for Berg dwelling, which would be an F2. Did you set bond?
I did. I set bond at 5,000.
And for Madam Clerk, the statute would be 810.02 sub 1 sub B.
Yes, ma'am. We'll note that on the paperwork. Okay, good luck to you. Thank you.
As far as the bond, where do I hear?
You can talk to the COs. They'll help you with that. Okay? Thank you. Okay, Mr. Minash, good morning. We have you back here in regards to this escape charge. I believe the state was able to get some additional information. And what is it, Ms. Fleming, that you wanted to provide this morning?
May I approach?
Yes.
I already did provide it to defense as well.
Thank you. So I guess my biggest question, oh, here it is. It's going to answer me. Okay.
I'm sorry, Judge.
I'm just reading this. Hold on. So I still don't quite understand because it looks like obviously OPD was notified on September 1st that Mr. Minash left the Bridges of America. What was kind of confusing to me is that when you look at the officer's charging affidavit, the charging affidavit, it says that he booked him into the jail on September 3rd at 1:06. But here we are at November 30th. Where has Mr. Minash been for the last 2 months? Has he been in OPD's custody? I mean, is that a mistake?
I cannot speak to the officer's intent, or I don't know if it is a scrivener's error.
No, he's been incarcerated all this time, Your Honor.
He has been here the entire time?
Mm-hmm.
Okay. Because that was the only thing, I think, when I asked the jail yesterday, they said it looked like he was TDY to the bridge, right?
I have him in custody as of 9.
But he was here, sorry, Your Honor, he was here this whole time.
He was here the whole time?
Yes.
We just never brought him over, or never brought him before.
Do we know why he waited all this time?
No, it appears that he should, the escape, it came from DOC, so technically he should be sent back to DOC, but the way that it was accepted into our system, it didn't work that way. They charged him as if he regularly escaped from, say, for example, our facility versus the actual warrant coming from DOC. But it seemed as if he needed to be sent back to DOC. So why was he scheduled for IAs? That's the question.
Okay, so I think what they're saying is the way they took it was that this is almost like a violation of his parole. And so when he got taken into custody, he should have just gone back to the Department of Corrections. But because they charged it as an escape, at some point they realized nobody was actually doing an IA for him on a new charge of escape. And there's been no new charge of escape, so I don't really know. I guess my point is, I'm only here to tell him that I don't have any new charges in front of me. All I have is that he absconded, he's now been picked up, and he should go back to the Department of Corrections to finish out whatever sentence he served. If they want to file new charges, that's up to them. But I don't have anything in front of me. That's a very convoluted way of looking at it, but that's the only thing I can think of.
Okay. So are you appointing us or no?
I'm not going to appoint you only because I think at this point, I need to tell the jail, you need to now notify the Department of Corrections. He clearly is in our custody and you need to come and get him. The good news is at least you're getting your time served. You may not be getting the same gain time, but at least all this time that you've been here isn't for nothing. I just wanted to make sure that somebody didn't accidentally send him back to the bridge and he's been doing all of his program at the bridge the whole time without us knowing about it. But he's been here.
Yep, as long as, like you said, Your Honor, you make sure they send him. I just don't want him sitting in the jail.
Yeah.
As he's already been doing.
So I will just go ahead and put on this order that he's now been taken into our custody, but the Department of Corrections needs to come and get him and take him back.
And someone did contact the Department of Corrections. They're just waiting for a follow-up call.
Okay? Well, we'll make sure we do that today then, okay?
But that was sent on the 4th, and I don't think they've had the follow-up call yet.
Okay. Well, hopefully. Okay. Good luck. Thank you, sir. So now this should be Michael Alvarado.
Yes, ma'am.
And Mr. Alvarado, is your date of birth August 19th of 1988?
Yes, ma'am.
Okay. So I have you here on case number 2022 CF 12721. This was an arrest warrant already signed by Judge Alicia Lattimore. She's the judge that determined probable cause. It was only my job to determine the bond amount on this case. I will go ahead and appoint the Public Defender's Office to represent you. As to count 1, I am going to set your bond at $1,000. On count 2, Judge Lattimore set it at $3,000. Count 3 is $250. I am going to include that you are not to have any contact with your girlfriend in this case. The order that you're being asked to sign right now is you just acknowledging that you've been made aware of the no contact order.
Yes,
If
ma'am.
you violate the no contact order, it can actually result in new charges filed against you as well as violating your conditions of release. I can't recall, are the two of you living together or you live in separate locations?
I live with my mother. She lives with her mother.
Is there anything at her house that you need to get?
My ID and my social security.
Okay, so I'll go ahead and put in the paperwork that you're to maintain a separate residence, but that if you need to go back to her house one time with law enforcement officers, you can get whatever you need at that point.
Thank you.
I'm also going to order that you not possess weapons or firearms, and that you not possess any illicit substances or alcoholic beverages while you're on release, okay? Oh, I'm sorry, then there is another case, which is case number 2022 MM519AW. This was a capias that was issued for a failure to appear on a trespass charge. The judge in Division 81 set your bond at $2,000, and I'll appoint the PD if they were not previously appointed. Okay? Good luck to you, sir. Thank you.
Thank you.
Okay, good morning, sir. Are you Ethan Batista Volta?
Yes, Your Honor.
Okay, and were you born on September 25th of 2002?
Yes, Your Honor.
Okay. So, sir, I did review the charging affidavit in this case. The case number is 2022 CF 13839AO. I did find there was probable cause. The case is assigned to Division 10. Let me ask you a question. I was having we were kind of having a hard time reading the affidavit of insolvency. The job where you work, you get paid weekly?
Yes.
Okay.
Yes.
Do you bring home the same amount every week? Or does
No,
it kind of change?
It sort of fluctuates.
Okay. So don't give me your worst week, but don't give me your best week. What, after they take out taxes and everything, what's kind of the average that you're able to bring home every week?
Honestly, it depends on the hours that I do because I get called by my manager to do hours, so I can't really decide on any of that. So I'd say maybe $500, sometimes more.
Okay. Do you usually get called every week to work hours? Or are there some weeks where you don't get called at all?
There's normally weeks where I don't get called because I work as a representative over the phone, so I work on a computer, so normally there's other representatives to answer other people.
So there's been weeks where you've had no pay at all?
Yes, ma'am.
Okay. So let's do... Okay. And I'm correct that you have no children, correct?
Yes, Your Honor, I don't.
Okay. So what I will do is, based on that, we'll go ahead and appoint the Public Defender's Office to represent you. I am going to set the bond on this case at $1,000. Obviously, because your grandmother's not here today, I do have to issue a no contact order. The order that the officer is showing you is just you signing to acknowledge that you've been made aware of that no contact order. Now, obviously, she's your grandmother and family, and at some point, you may want to have contact with her again, and she may want to have contact with you. But until this gets decided by a judge, just keep in mind that you're the one that has the order, and if you violate it, you're the one that's going to go back to jail. So do you have someplace else that you can stay?
I can ask a couple of my friends when I do get out. I'm
Okay.
sure they'll let me.
Talk to them, and then talk to your attorney and see what we can do. I will allow you to return one time with law enforcement officers so that you can retrieve any belongings you might need at your home, but you are going to not be able to return there except for that one time, and you do need to maintain a separate residence. I'm also going to order that you not possess any weapons or firearms. Okay?
Yes, Your Honor.
Good luck to you, sir. Thank you.
Do you know how long that does last, that I won't be able to see my grandmother? I'm sorry.
Until you get in front of the judge, so that's kind of up to you and your attorney.
Your Honor, how much was the bond?
1,000.
Yeah, that's my first.
Okay, you're all set, sir. Thank you. Okay, good morning, sir. You Tony Key. And Mr. Key, were you born on October 18th of 1958?
Yes, ma'am.
Okay. So, sir, this looks like, this is a charge that came in 2022 CF 13819AO. It's out of Division 17. I have reviewed the charging affidavit, and I am finding that there's probable cause for the aggravated battery. He's currently in jail on all these other charges, is that correct?
Yes.
Okay. Okay, so I'm gonna keep his bond set at $5,000. He's not to have any contact with his mother. He's not to return to her location. If there's any belongings there that he needs, I'll allow him to return one time with law enforcement officers to retrieve it, and he's not to possess any weapons or firearms. And if I didn't say, I am appointing the Public Defender's Office. Okay? Good luck to you, sir. Thank you.
5.
Oh, they already did this already.
I think this is for a separate incident.
I already been to court for this already.
Just put, refused and I'll sign it.
I'm sorry. Yeah, take that with you.
Okay, good morning, sir. Are you Robert Ross?
Yes, ma'am.
And were you born on August 29th of 1990?
Yes, ma'am.
Okay. So, sir, this is a case that was filed with the state attorney's office. They actually filed an information. Count 1 is an aggravated assault with a deadly weapon. Count 2 is battery domestic violence. This is in case number 2022 CF 12205AO. I will go ahead and appoint the public defender's office to represent you.
Excuse me.
I'm gonna go ahead and set your bond at $5,000 on count 1 and $100 on count 2. I am gonna order that you have no contact with your wife. Obviously, that order that you're signing there is indicating that you acknowledge that no contact order. I'm not saying that it has to remain in place forever, but the only person that can change that is the trial judge. So you need to get with your attorney to have them change that if you want that to happen, or you can get arrested for a new law violation and for violating conditions of your release.
Excuse me, Your Honor, can I ask you a question?
Yeah.
I was in jail for this case right here that happened in March, which was the warrant for, and I went to court for that the October 12th, and they dropped those charges.
Then it's possible that this is them refiling it. So they can refile the charges.
It was filed 10/19, and he's been in KPS since.
Yeah, I didn't get the impression it was a refile, though. I think this is a new incident.
This is if it happened in March, what the officer told me, I was locked up when I was going to court for this.
I would talk to your attorney, because if they want to contest it, then that's something that obviously they're going to have to do with the trial judge. I'm just telling you what your bond is.
I understand, Your Honor.
Okay, so it does say no contact with the victim, to maintain in a separate residence. Do not possess or consume any alcohol, illegal drugs, or controlled substances without a valid prescription. Do not possess any weapons or firearms. I'll include that if you need to pick up any belongings, you may do so one time with law enforcement officers, okay? Talk to your attorney. Hopefully, once they get all the discovery, they'll be able to figure it out for you. Hi, good morning, sir. Are you Clive Schloss?
Oh, yes, ma'am.
And were you born on August 5th of 2003?
Yes, ma'am.
Okay. So, sir, this is an arrest warrant that was signed by Judge Alicia Lattimore. She's determined probable cause. This is in case number 2022 CF 13103AO. My job is to determine the bond set in this case. It is assigned to Division 10, and I will go ahead and appoint the Public Defender's Office to represent you. Unfortunately, because of the count 1, armed burglary of an occupied dwelling, that is a first-degree misdemeanor punishable by life. You're not entitled to a bond, and based on the information, I'm not inclined to set one. I will set bond on count 2 at $1,000 and count 3 at $100. I am going to order that you not have any contact with your ex-girlfriend and that you not possess any weapons or firearms. Yes.
And you're just,
And no return.
and just to be clear, you said it was a first-degree misdemeanor punishable by life?
First-degree felony. Sorry.
I knew what you meant, but just so the record was clear in case there was ever.
Yeah. Sorry. That's the county judge part of me coming out.
It's okay.
It'd be quite entertaining if we had misdemeanors punishable by life. Okay, good morning. This is Quantea.
Quante.
Quantea, and your last name is Dylan Davies.
Yes, ma'am.
Davis. Okay. And your date of birth is January 23rd of 2002.
Yes, ma'am.
Okay. So this is case number 2022 MM 8023AO. I have read the charging affidavit. I am finding that there's probable cause for the charge of battery. I will go ahead and appoint the public defender's office to represent you. Sir, without your mother being here today, I do have to issue a no contact order between the two of you.
Yes, ma'am.
That order that you're signing is just you acknowledging that you've been made aware of the no contact order. If you do violate it, you can be picked up on new charges as well as violating conditions of your release.
Yes, ma'am.
It's my understanding you do not live with your mother though, correct?
No, I do live with her.
You do live with her?
Yeah, I'm on the lease with her.
Okay. Do you have someplace else that you can
Yes,
live until this gets sorted out?
Yes,
Okay.
ma'am.
So I will go ahead and do this. I'll release you onto pretrial release so that you don't have to pay a monetary bond, but you will be supervised by pretrial services with the condition that you not return back to the scene. You maintain a separate residence, but I will let you go back one time with law enforcement officers so you can get any belongings that you may need. And I'm just going to order that you not possess any weapons or firearms.
Yes,
Okay?
ma'am.
Good luck to you, sir. Thank you.
Thank you.
Thank you. You are Johnny Figueroa. And Mr. Figueroa, you were born on December 21st of 1982. Okay. Sir, this is an arrest warrant in case number 2022 MM 7729AO. Probable cause was determined by Judge Gibson. She signed off on this. It is assigned to Division 50, and I will go ahead and appoint the Public Defender's Office to represent you. You do qualify for pretrial release, but understand that I do have to issue a no contact order since your brother's not here today. The officers are going to give you a no contact order that you'll sign. It's just acknowledging that you're aware of the no contact order. Obviously, this is your brother, he's your family, so it is possible that this could change, but until Judge McGinnis, the trial judge, actually changes it, you're the one who carries the risk of going back to jail. It's my understanding you do have someplace else you can stay, though, correct? Okay, so I'm gonna order that you not return to the scene, but that you maintain a separate residence, but that you are allowed to return one time with law enforcement officers to retrieve any belongings, and that you not possess any weapons or firearms. Okay, good luck to you, sir. Thank you. Hi, good morning. Are you Carol Rivera?
Yes,
And were you born on May 9th of 1994?
yes.
Okay. Ms. Rivera, I did read over the charging affidavit contained in the court file. Technically, there's probable cause for a battery, so this is assigned to Division 50, and I'll appoint the Public Defender's Office to represent you. Without your boyfriend being here today, I do have to issue a no contact order. That means that you can't have any contact with him until Judge McGinnis tells you something differently. I am going to get you to sign off on that order. It's just acknowledging that you're aware of the no contact order. It is my understanding, though, that you have someplace else that you can stay, correct?
I do, yes.
Okay, so I'll go ahead and release you on pretrial release so that you do not have to pay a monetary amount. But the conditions are that you have no contact with him. Obviously, you're not going to be able to return to the home that you share with him. You'll need to maintain a separate residence, but I will allow you to return one time with law enforcement officers so that you can retrieve any belongings. I'm also going to order that you not possess any illicit substances or alcoholic beverages or weapons or firearms. Okay, you're all set. Thank you. Terry Roberts?
Yes, ma'am.
And were you born July 1st of 1974?
Yes,
Okay. So this was a warrant that was signed off by Judge Jewett, he determined probable cause. I just need to set your bond. Without you telling me anything about the facts of the case, I just want to verify that I'm correct the way I read this. You and Ms. Parker do not live together, correct? No, we don't. Okay, perfect. So the only thing I'm going to do today, as far as keeping up with what Judge Jewett implied, is the no contact with Deborah Ann Parker. They're going to give you an order that says that you're signing off on that for no contact. If that needs to change, Judge McGinnis is the only one that can change that. You signing it is just you acknowledging that if you violate it, you can be arrested for a new law violation as well as violating conditions of your release. So that's just what that piece of paper is there.
Yes, ma'am. I have one question.
Yeah.
Like everybody else going back one time with the officer to get their things, can I do the same?
Yeah, I was definitely going to ask you if you had any possessions over there that you need. So you need to be able to do that?
Yes, ma'am.
Okay, so I'm just going to include with the no contact order that you maintain a separate residence. I will allow you to return one time with law enforcement officers if you do need to retrieve any belongings from her home. You do qualify for pretrial release, so I'll go ahead and release you on pretrial release with those conditions, and also include that you not possess any illicit substances or alcoholic beverages, and that you not possess any weapons or firearms. If I didn't say it before, I am also appointing the Public Defender's Office to represent you. Yeah, don't return to her location, okay?
Okay, except for that one time, right?
Except for the one time with law enforcement. Yes, you're correct. Thank you, sir. Good luck to you.
Thank you, ma'am.
Is it Kasani? Kasani. And Tolentino is how you say your last name?
Yes, ma'am.
Okay. And you were born March 23rd, 1994?
Yes, ma'am.
Okay. And I'm assuming, is this your sister? Okay. Hi, good morning, ma'am. Can you raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Swear.
Okay. And can you tell me your name?
Caitlin Adamas.
Okay. And Caitlin, it's my understanding you and the defendant are sisters, correct? And the two of you live together?
Yes.
With her two children?
Yes.
Okay. And I'm assuming based on the way the facts occurred that you're okay with her coming back home? And, okay. Let me ask you a question. I know that she has two children, and the officer certainly indicated the children in the report. Did anybody tell you that they were calling DCF?
No.
Okay. So here's what I'm gonna do, Ms. Tolentino. I am finding probable cause for the charge of battery. It's assigned to Division 50. I'll go ahead and appoint the Public Defender's Office to represent you. You do qualify for pretrial release, so I can release you without having to pay a monetary bond. You'll just be supervised by pretrial services. The conditions are that you have no hostile contact with your sister, so no more fighting, no more arguing, and that you not possess any weapons or firearms. If for some reason DCF was contacted, I can't tell from the report. Just try to comply with any orders that they, or plans that they provide with you, okay?
I have a question.
Yeah.
So, I've never been through this before. So what would be my bond?
So you're not having to post a monetary bond. I'm just letting you out. The people that came and interviewed you, that's pretrial services, they're just gonna come with you, and you'll continue to check in with them until, and then I would talk to your attorney, and then your attorney can kind of tell you what the next step's gonna be.
Okay, so I'll be released today?
Yes, yes, very shortly, actually. And are you probably gonna be the one that picks her up?
No, probably my brother.
Okay, okay. Well, just let him know she should be available pretty soon, okay?
Okay.
Was there anything else you wanted to tell me? I didn't mean to just
No,
not
you're good.
to you.
No, that's fine.
Okay, 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 you're both set. Thank you so much. Good luck to you both. And this is Sydney Walker.
Yes, ma'am.
Mr. Walker, were you born January 30th of 1993?
Yes, ma'am.
Okay. So, Mr. Walker, I did review the charging affidavit in this case, 2022 MM 8016AO. I have determined that there's probable cause for the charge of battery. It's assigned to Division 50. I will go ahead and appoint the Public Defender's Office to represent you. Obviously, with your girlfriend not being here today, I do have to issue a no contact order with her. That piece of paper that the officer is giving you is just acknowledging that you're aware of the no contact order. It is possible to change this, but it has to be done with Judge McGinnis, the trial judge. So just keep in mind, if you violate the order until it gets changed, you're the one that runs the risk of going back to jail for a new law violation, as well as violating conditions of your release. So it's my understanding you do live together, correct?
Not anymore.
Not anymore? Do you need any items at her house?
No, she was staying with me at my mom's house. She actually went to her grandmother's house now.
Okay, okay. So I'm just gonna, with the no contact, oh, thank you. I'm just gonna go ahead and, thank you. Put that you're to maintain a separate residence and not to possess any weapons or firearms, okay? And you're all set. Okay, good luck to you, sir. Thank you.
Do I have a bond?
Oh, I'm sorry. Yeah, it's $500. Okay.
Thank you so much.
Sorry, I knew I forgot something. Okay, and you are Victor Manuel Calderon Matos?
Yes, ma'am.
And so were you born on March 19th of 1970?
Yes, ma'am.
Okay. Sir, this is a warrant out of Lake County. It does say that it has a bond on it of $5,000. So you are able to bond out with that, or you can wait for Lake County to come pick you up. They are supposed to come pick you up within about 24 hours, okay?
Oh, I was told by my family that they got a hold, that they couldn't bum me out. Can I bond out from Orange County?
Yes, the hold is for Lake County.
Yeah, the hold's for Lake County, so as long as you post the $5,000 bond, then yes, they should let you out.
There's no
other hold.
problem for me to bond out from Orange County, though.
Correct.
Okay.
Okay.
That's what my family was told.
Maybe there was just some misinformation. Hopefully we'll get it resolved today, okay? Thank you. Albert, is it Gilreath?
Yes, ma'am.
Did I say that properly?
Gilreath.
Gilreath, thank you. And Mr. Gilreath, you were born on July 1st of 1999?
Yes, ma'am.
Okay. So this is a warrant out of Brevard County. It does have a bond set of $5,000. So again, you can either bond out on the $5,000 bond, or you can wait for Brevard to come and get you. They should come and get you within the next 24 hours.
Yeah, I was told I had 2 holds.
Is it possible because he's on probation they're holding him?
No, the probation didn't come in yet. It's just the Brevard. His fingerprints cleared, so it's just the Brevard.
So sometimes what happens is, even though when the officer picks you up and you have that warrant and it shows a bond amount, until the jail actually processes all the paperwork, they won't let you go even if your family makes the bond. So hopefully now she's saying that your fingerprints went, so you should be able to get out. Okay, good luck, sir. Thank you. Levi Bradford?
Yes, ma'am.
Mr. Bradford, were you born on January 11th of 1999?
Yes, ma'am.
This is case number 2021 CF 704AO. It's a violation of probation warrants signed by Judge Navarro. She has set your bond at none. Did you want the Public Defender's Office appointed to represent you, or are you going to hire your own attorney?
Public defender.
Okay, we'll go ahead and appoint the Public Defender's Office to represent you, and they'll try to get you in front of Judge Navarro for a bond hearing, okay? Good luck to you, sir. Thank you. Courtney Burney.
Yes, ma'am.
Mr. Bernie, were you born on October 1st of 1995?
Yes, ma'am.
Okay. I missed this. So you have two cases, 2022 CF 1383280. Hold on one second. So that, I am finding that there's probable cause on those charges, and I will stay the bonds for 4,300, 3,500, and 1,000. However, this also does trigger a violation of your probation in case number 2020 CF 3954 BO. I will go ahead and appoint the Public Defender's Office to represent you on both sets of cases, but the bond on the VOP is set at none. Okay? Good luck to you, sir. Thank you.
Here you go, sorry.
Hi, good morning, sir. Are you Travis Daniels?
Yes, ma'am.
And were you born on March 1st of 1994?
Yes, ma'am.
Okay. Okay. So I have three cases. The new charges are under 2022 CF 13834AO out of Division 12. This is possession of cannabis with intent to sell or deliver. I will go ahead and find probable cause. I'll appoint the Public Defender's Office to represent you, and I'll keep your bond set at $1,000. However, this does violate your probations in case number 2012 CF 5604AO. That's out of Division 20. I will appoint the Public Defender's Office, but the bond is set at none on the violation of probation. There's also 2016 CF 14872AO, Division 20 violation of probation. The bond is set at none, and I'll appoint the Public Defender's Office to represent you. Unless you were going to hire somebody else. I just decided there's not an affidavit. Did you want the PD on your cases?
No, I'm gonna hire you an attorney.
You're going to hire an attorney? Okay, so I'll take that back. Do you know who you're going to hire?
No, not yet. No.
Okay. Does your family know that you're here on a no bond?
Yes.
Okay. I just wanted, is there any attorney that you want me to contact to come and see them? Come and see you, I mean? Or you just want to wait and let your family figure it out?
I just wanna.
Okay. Okay, good luck, sir. Thank you. Marcus Henry? Mr. Henry, your date of birth is August 25th of 1981. Sir, this is case number 2021 CF 14761AO out of Division 14. It is a violation of probation signed by Judge Strobridge. He has set your bond at none. Were you going to hire an attorney, or did you want the public defender?
Public defender.
Okay, we'll go ahead and get the public defender appointed to represent you, and they'll try to get you back in front of Judge Strobridge. Okay? Good luck to you, sir. Thank you. Devontae Robbins.
Hello, how you doing?
I'm good, Mr. Robbins. Just verifying you were born March 12th of 1999.
Yes, ma'am.
Okay. So I have case number 2022 CF 13830AO. This is out of Division 11. I am going to go ahead and appoint the Public Defender's Office to represent you. I will go ahead and agree that there's probable cause for the charges. I'll keep the bond stayed at 100,000 on count 1, 1,000 on count 2, 3,500 on count 3, and I'll drop count 4 down to $100. That's in Division 11, but this also violates your probation in 2020 CF 3954AO out of Division 17. I'll go ahead and appoint the Public Defender's Office to represent you, as that bond will remain at none. Okay, good luck to you, sir. Thank you. Adrian Sankey?
Yes, ma'am.
Okay, and Mr. Sankey, were you born on May 2nd of 1991?
Yes, ma'am.
So this is a warrant for a violation of probation in 2014 CF 9900AO out of Division 11 with Judge Navarro. She has set your bond at none. Are you hiring your own attorney or you want a public defender?
Public defender at the moment.
Okay, we'll go ahead and appoint the public defender's office to represent you, and they can get you back in front of Judge Navarro about a bond hearing. Okay, good luck to you, sir. Thank you.
And Your Honor, he also has the HRSO detainer.
Okay. Okay, you're all set. Good luck to you, sir. Thank you. That's the one where he just needs to make sure he registers if he gets out, but he's not getting out anytime. So I'll let Navarro tell him that. Are you Antonio Scott?
Yes, ma'am.
And Mr. Scott, were you born on February 17th of 1978?
Yes, ma'am.
Okay, this is an arrest warrant for a violation of probation. It's in case number 2021 CF 677 out of Division 16. Judge Barber signed the warrant. She has set your bond at none. Did you want to see if you could get the public defender, or are you going to hire your own attorney?
Public defender.
Public defender, okay.
I talked to my probation officer. They said they were gonna give me a bond.
You'd have to get back in front of Judge Barber for that. The warrant she signed has no bond, but we'll get you the public defender, contact them, and they'll try to get you a bond hearing with her. Okay, thank you. How about Freddie Lee Thomas? Mr. Thomas, were you born on June 10th of 1993?
Yes, ma'am.
Okay. So I have 3 cases here. The first one is 2021 CF 14217AO. This is out of Division 22, signed by Judge Harris for a violation of probation. She did set your bond at $1,000 on that case. Then in regards to case number 2021 CF 13926AO, that's a Division 22 case as well. She also gave you a bond of $1,000 on that case. And then the third case is 2022 MM 2506AO, that's out of Division 50. That was signed, I believe, by Judge McGinnis, but he set your bond at none. Go figure. So let me ask you, Mr. Thomas, did you want the public defender's office to represent you on these cases, or were you going to try to hire your own attorney? Public defender? Okay, so we'll go ahead and appoint the public defender's office on all 3 cases, and then you do have bonds on the felony, but your attorney can try to get you in front of Judge McGinnis to get a bond hearing on the misdemeanor case, okay? Good luck to you, sir. Thank you. Hi, good morning, sir. Are you Terrence Foy?
Yes, I am.
And were you born November 23rd of 1975?
That's correct.
Okay. So, sir, this is a violation of probation warrant that was signed by Judge Johnson in case number 2022 MM 3836AO. He has set your bond at none. I will go ahead and appoint the public defender's office to represent you, and they can try to get you in front of him to do a bond hearing, okay? Good luck to you, sir.
I don't have a court date on the violation?
You will, but it'll come on your paperwork and probably like later this afternoon.
Okay, all right, thank you.
Okay, thank you. Is that correct?
Good afternoon, Your Honor. This is Laura Royo, State Certified Interpreter and previously sworn.
Good morning, or good afternoon, Laura. It's Judge Martha Adams. Are you at lunch, or can you do one of our initial appearances?
Absolutely. We have a rotation for lunch now, so I'm yours.
Okay, wonderful. So I actually have Juan Gomez. He's actually here for an in-jail arraignment. And this is on case number 2009 CT 81680, and then he has a second one in 81780.
Yes, Your Honor. 1 second while I establish connection.
I'm sorry, 8017801680. Sorry. You watch, by Friday, I'll be like,
Connection is established.
good afternoon, Mr. Gomez. You're here on two cases where you failed to appear for leaving the scene and driving without a valid driver's license. Were you wanting to try to resolve these cases today, or should we go ahead and set them off so you can have some more time to talk to your attorney?
It's tied to a grand theft, Your Honor, so I wouldn't advise the client not to plead until
Sorry, Your Honor. I'm having difficulty understanding counsel. Could you, thank you, please, and repeat that for the interpreter?
both of these charges are tied to a grand theft. My review of the case, so I would advise the client not to resolve these two charges until he deals with the grand theft of a motor vehicle.
Okay, so Mr. Gomez, your attorney is requesting that we enter a plea of not guilty on your behalf. I can set you for a pretrial conference in Division 83 on December 12th at 8:30. Ms. George will give you the information for your attorney, Ms. Altawam, and she can come and talk to you, and we can either try to get you out on a bond hearing, or maybe after she's had a chance to talk to your attorney in the felony case, we could see if we could resolve these. But she'll be in touch with you soon, okay?
Okay.
Okay, that's fine.
Okay. Okay, Laura, thank you so much. Have a wonderful day.
Likewise. Bye-bye.
Bye. Okay. So, Ms. George, do you want me to appoint your office? And hey, would you like me to appoint your office and then we'll waive his appearance?
Yes, Your Honor.
Okay. So in case number 2022 MM 801380, this is in Division 85, I am finding there's probable cause. I will go ahead and appoint the Public Defender's Office to represent him. I'll stay the bond at $500. He is currently out on bond for a trespass. Does the state have any strong feelings one way or the other?
Seriously request that you take no action.
Yeah, based on everything that's going on, I'll just take no action on the out on bond case, and he'll have the bond for the new charge, okay? Are ya? You coming and just hang out with us today? Aw. I'm sorry, it might not be very exciting. Or I don't know. Knock on wood, I could have just jinxed us all. Okay. Good morning, or good afternoon. Are you Mr. Leston?
Yes, ma'am.
Okay. Mr. Leston, you're here on case number 2022 MM 685AW. This is in Division 62. I have reviewed the charging affidavit, and I am finding there's probable cause for the charge of battery. We'll go ahead and appoint the Public Defender's Office to represent you. And I'm assuming there's no offer.
No, not at this time.
And so at this time, sir, I'll go ahead and keep your bond stayed at $500. I am going to order that you not have any contact with the alleged victim in this case, and that you not return back to that location. Okay? Thank you, sir.
Yes, ma'am.
Could he have a one-time return with law enforcement to gather his belongings?
Yes, I'm sorry. Yes, you may return one time with law enforcement officers so that you can retrieve any belongings that you may need.
Yes, ma'am.
Okay, thank you. Sharma McLaughlin?
1 minute, Your Honor. Since you're bringing around,
Okay, good afternoon. Are you Sharma McLaughlin?
Yes.
And ma'am, were you born on September 29th of 1958?
Yes.
Okay, so I have you here on case number 2022 MM 802180. It is a charge of trespass. Did you want to see if we could try to resolve this today, or did you want to just have a bond set?
Resolve it today.
Want to try to resolve it today?
State did convey an offer to Ms. McLaughlin of an adjudication of guilt, credit time served, and no return to the Wawa.
Okay, fine.
Would you like to accept the state's offer and enter a plea of no contest? Your Honor?
Okay, Ms. McLaughlin, can you raise your right hand for me? Do you swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth? Thank you. So I'm taking your, I'll take it. No, that's okay. I have the plea form that you signed here in open court. Do you have any questions about any of the rights that are on that form?
No?
And you're going to be entering a plea of no contest. Has anybody forced you or threatened you to do that this morning? And you understand if you're not a U.S. citizen, entering into a plea today could subject you to deportation? Okay. So, ma'am, I will go ahead and accept your plea. I will adjudicate you guilty. I'll give you credit for the 2 days that you served previously in the Orange County Jail and release you on this charge and this charge only. I'm going to order that you not return back to that particular Wawa that was located on Raleigh Street. There are court costs, but I'll give you a year to pay those court costs back. Do you have any questions for me?
No.
Okay, you're all set. Thank you. Good luck to you, ma'am. Okay, good afternoon, sir. Are you Michael Allen Taylor?
yes,
And Mr. Taylor, were you born on August 29th of 1969?
yes,
Okay. So, Mr. Taylor, you're here on 2022 MO 1006AO. This was a capias that was issued when you failed to appear for a pretrial conference. They did give you a bond, but was this something that you wanted to try to resolve today, or did you just want to go ahead and try to bond out?
I don't have any money.
That's okay. Any monies that you would owe, I would give you a year to pay it back. I'm more concerned about if you want to get out of jail today or if you want to try to bond out today.
I'd like to get out of jail today.
Yeah, okay. Ms. Fleming, what was the state's offer?
State did convey an offer to Mr. Taylor of an adjudication of guilt, credit time served, and no return to Family Dollar at 1340 West Gore.
And he would like to accept and enter a plea of no contest, Your Honor.
Okay. Mr. Taylor, while you're there, can you raise your right hand for me as best you can? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I swear to tell the truth, the whole truth, and nothing but the truth.
Excellent. Thank you so much. You can put your hand down. Now, I watched you sign the plea form. Did you have any questions about any of the rights that you're giving up to enter a plea today?
I wasn't at the Family Dollar. I was on another block. I wasn't at the Family Dollar. I was somewhere else.
Okay. Well, Mr. Taylor, let me ask you a question. for me to take a plea today, and I can take a plea of no contest, which means you're just resolving it because it's in your best interest to do so, but it is for a charge of trespassing at that Family Dollar. Do you want to enter the plea of no contest because you just want to resolve your case today, or did you want to have some more time to talk to your attorney?
I want to just resolve the case.
Okay. And you don't feel like anybody's forced you or threatened you to do that today?
No.
Okay. So, sir, I will go ahead and accept.
Sorry, Your Honor.
Yeah. Don't want him to take the plea?
It's the, when I looked at the notes, I didn't see any competency issues.
Okay. It's up to you.
But could I have just a moment?
Sure.
Mm. Oh, he pled. Okay. Okay, even though there were some, Your Honor, he has pled before. I just wanted to double check because I saw the ICP, but he's fine to proceed.
Okay. So, Mr. Taylor, because you're wanting to resolve your case today, I will go ahead and accept your plea. I'll adjudicate you guilty. How many days does he have total?
6.
6. I'll go ahead and sentence him to 6 days in the Orange County Jail with credit for the 6 days he's previously served. I'll release you from this charge and this charge only. I am going to order that you not return back to that store on 1340 West Gore Street. And then there are court costs. This is a city case, so it's $223 and then a $10 filing fee. But Mr. Taylor, I'll give you a year to pay that back. If you don't pay it off in a year, they can suspend your driver's license. So if you want some more time, just write to me and let me know, okay? Okay, good luck to you, sir. Thank you. Hi, good afternoon. Are you Cynthia Butler?
Hello, speaking.
I'm sorry?
Yes, yes,
Okay.
ma'am.
And Ms. Butler, were you born on October 30th of 1965?
Yes.
Okay. So let's talk about, I have one case here that's just a newer case from 2022 MM 8015AO. It is for a trespassing charge. I can try to resolve that case with you, and then it looks like the other case you're here for is a capias when you failed to appear at pretrial conference on another trespass charge.
That case was closed out.
Your Honor, can I say I'm not supposed to be here?
Okay.
And that,
How about, let's not all talk to me at the same time, because all I hear are voices, and it's kind of freaking me out.
can I go first?
But let me just ask, because I think she said something that's very important for you said the one case has already been closed out?
Yes, the failure to appear.
The failure to appear, she's resolved that one?
Yes, it was a ROR.
Oh, so she's already been ROR'd on it?
On the warrant, it was ROR, yes. So we're just seeing the trespass case.
Yes, so it's because of the competency, Your Honor, they ROR, which is why we can't take a plea on this new law.
Okay. So, Ms. Butler, one, you've already been released on the failure to appear. So you're actually only here in front of me on the new trespassing charge in Division 63. What did you want to ask me or say?
I just want to say that from the very beginning, I never should have been here. The leasing agent took money from my account and put me out of my apartment when I went to the store and came back and trespassed me that time. I didn't come to court because I was trespassed and I was homeless.
But let me tell you, and I'm
that's
not,
how I
I'm not
missed
telling
this.
you I don't want to hear anything that you have to tell me. I'm just telling you that everything that you tell me in here is being recorded.
That's good.
Well, but my concern is Ms. Fleming represents the state of Florida, and she's the one that prosecutes you. And while you may say something that you feel is very important and come off across as innocent to you or not being bad for you, it could be an admission to one of the elements of the crime. So that's why I just don't want you to talk about that.
But
So-
it also, Your Honor, it would be considered the guy that I was dating that took me through this. Today, while I was in the cell, they were throwing stuff across my body. My hair is gone, my teeth is broke, my stomach is up, my vagina is gone, my butt, hips, and thighs are gone, shit's in my hand and my nails. They've been doing all kinds of stuff to me. I'm not supposed to be here.
Okay, well, let's see if we can try to find somebody to help you with that. So I'm gonna go ahead and appoint the Public Defender's Office to represent you.
But why would they represent me, Your Honor, if they took money from my account and put me out of my apartment and I came to court the first time?
Those are
Second
different
case-
people. Those are different people. The attorney I'm appointing, that person's gonna try to help you. That's different from the people you're talking about before.
No, not the people on this situation, but on the situation with the apartment. When they took the money from my account, I couldn't stay there. When I came back, the locks was changed. So I got out. I came back the next day and tried to speak to another agent in the office to get back in the very next day without calling the cops in. And I came in here and I agreed because they told me this day not to, and they came back the next day and they escorted me off the property. But I didn't come to court for this because I didn't have an address. And I didn't have a mail or a phone number. They stole my telephone number. They stole food, they stole sodas, they stole food, they turned the AC on. They came in and laid down while I was sleeping. The manager of the office.
Okay, well, let me do this. Here's what we'll do. I'll see if possibly you can be released on mental health pretrial release, or I'll keep the bond set at $500, and then we'll go from there, okay?
Okay, and one more thing. Miranda Walton is behind all of this. He's been sleeping with the universe, the nation. And he's the one took me through this with my family members. There are 23 of them that's been trying to knock me from day to day, but they get in and they get right out. I don't understand this. I don't understand the systems. I don't understand how they crawl through the cracks, and I'm always here when they do something to me. And Renee is my sister, and that's the one that comes through and pick everybody up out of jail.
Okay.
It's something that they want with my kid. It's something that they want to do with my kid. What's happened to my kid already?
Pretrial services, and maybe we can try to figure some of this out for you, okay?
And while I'm here,
No, I gotta let you go. There's so many more people behind you, but I'm gonna let them talk to you and see if we can try to work this out. No, ma'am, I gotta go.
I'm here, they try to take my kid from me. And
Okay.
knock it and hit it and rape it.
Okay. I did jinx this. Told you. Okay, good. Allison?
Yes.
And your last name is Woodruff, correct?
Yes.
And were you born on August 1st of 1965?
Yes.
Okay. This is case number 2017 MM113112AO. It looks like it's for a charge of resisting an officer without violence. A warrant was issued when you failed to appear for a status hearing on June 20th in 2018. The bond's been set at $500. And we're just gonna see if she can bond it out.
She's in comp proceedings, Your Honor.
Okay, so, Ms. Woodruff, your attorney will talk to you and see if we can either get you a bond hearing or try to resolve it at a later date, okay? Good luck.
Excuse me, Your
Thank you.
Honor. I have a $5,000 bond.
Did I say 500? I meant to say 5,000. Okay,
And I will waive the appearance, Your Honor.
okay. What's interesting is nothing in her two new cases say anything about that. Would you agree? I don't see any competency motions filed
In which case?
in the cases that she's out on bond for.
Lovesmith?
Yeah, or at least I just completely, because I looked at, so she's out on bond in 2022 CF 7076AO. She's out on an ROR. Mr. Joshua Martin Harry Sinclair represents her, and information was filed on November 3rd for possession of cocaine. I don't see anything in there. Okay. No? Okay. So, in that case, in regards to, let's go from the very beginning, 2022 CF 13825AO. I am finding probable cause as to the three charges. I'll stay the bond amounts. That's in Division 14. I'll go ahead and appoint the Public Defender's Office to represent her, and we'll waive her appearance today. However, she's currently out on bond in 2022 CF 7076AO. That is a charge of possession of cocaine. I am going to revoke the ROR, set her bond at none. She's also currently out on bond in 2022 MM 7375AO, which is actually a trespass for the exact same store that she was being trespassed from in this new case. That information was filed on November 18th, so I am going to revoke the ROR in that case and set her bond at none. And I believe she does have the public defender on both of those.
Yes, Your Honor. And I believe you have
The state was just gonna ask for a no return on the new law.
Yes, and no return back to that Circle K. Are you Robert Spencer?
Yes, ma'am.
Okay, thank you. Just give me 1 second here. Okay, so Mr. Spencer, this is case number 2022 CT 5899AO, as well as 2022 CT 5900AO. One's a driving while license suspended or revoked with knowledge, the other attaching tag not assigned. You do have the Public Defender's Office. We can try to resolve your cases today, or we can set them off. What would you like to do?
Resolve my case, ma'am.
The offer from the state as to both, I'm here, Mr. Spencer, is an adjudication of guilt, credit time served, and court costs. Mr. Spencer would like to accept and enter a plea of no contest, Your Honor.
Okay. Mr. Spencer, can I get you to raise your right hand for me as best you can? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. I've been handed your plea form that you and your attorney have signed. Any questions about any of the rights on the form?
No, ma'am.
You can put your hand down. Thank you. She's indicated you want to enter a plea of no contest. Do you agree that no one has forced you or threatened you to do that today?
No, ma'am.
Okay. And sir, last but not least, do you agree, do you agree that if you're not a U.S. citizen, entering a plea today could subject you to deportation?
Yes, ma'am.
Okay. So, sir, at this time, as to both cases, I will adjudicate you guilty. I'll sentence you to 6 days in the Orange County Jail with credit for the 6 days that you've previously served. I'll release you from both of these charges and these charges only. There are going to be court costs on each case with the cost of prosecution and public defender lien, but I'll go ahead and give you a full year to pay all of the money back. So if you don't pay it off in a year, they can suspend your driving privilege until you do. Just write to me before that year runs out if you need extra time. Any questions?
Yes, if you have questions.
Any questions?
No, ma'am.
Okay, you're all set. Good luck to you, sir. Thank you.
Yes, sir. You're going.
Okay, Maurice Clark.
Yes, ma'am.
Mr. Clark, your date of birth is November 6th of 1990?
Yes, ma'am.
Okay. So, Mr. Clark, you're here on 2022 MM 505AA. It's a charge of trespass. I have found that there's probable cause in the case. Were you wanting to try to resolve this today, or did you want to just try to bond out?
Your Honor, may we approach?
Sure. Give me 1 second. Okay, so Mr. Clark, because of the way that the charging affidavit reads, the state doesn't have an offer to resolve your case today. So I will go ahead and keep the bond set at $250 on that charge, and I am gonna order that you not return back to that location or have any contact with any of the victims or witnesses. Now, the problem is that you're currently out on an ROR in regards to 2022 MM 263 AA. Because you did pick up a new trespass law violation, I am gonna go ahead and revoke your bond or revoke the ROR. The bond will remain at none, but we'll have your public defender get in touch with the judge so they can try to see if we can do a bond hearing for you, okay? Good luck to you, sir. Thank you. Okay, good afternoon, sir. Are you Rick Greer?
Yes,
And were you born on May 12th of 1990?
yes.
Okay. So, sir, I have you here on case number 2022 MM 8025AO. I did review the charging affidavit in this case. I am finding that there's probable cause. There was not an offer made, though.
Not at
So at this time, sir, give me 1 second. Okay, so I'm gonna go ahead and determine that there is probable cause for the 3 charges. I will go ahead and stay the bond amounts at $500 each. I am gonna order that you have no contact with the alleged victim in this case and that you not return back to that location. I will also appoint the public defender's office to represent you. Okay, good luck to you, sir. Thank you.
Did you find probable cause?
I read it. I read the charging affidavit.
They didn't give you no evidence, just words?
Probable cause was determined based on the 4 corners of the charging affidavit. So yeah, I found it. I found the evidence I needed.
So are you aware that the first sentence on that statement was that he got called for shoplifting? He got called to the store for shoplifting.
Who's he? You?
No, the officer that showed up.
The officer that showed up got arrested for shoplifting?
No, the first line on the statement that the officer wrote for the narrative is that he got called in response to a shoplifting.
Okay, what does that have to do with anything?
They called the cops and said I was shoplifting. They literally committed entrapment. As in, if I would have left the store, they would have assumed I was shoplifting. When in actuality, I was in there giving them problems because they would not ring up my food. So it was a lose-lose. Either I stayed there and they lied on me and said I threatened them, or I left and I looked like I shoplifted. So if I would have came back to the store anyway, because I literally live in my truck and go to the gym right behind that gas station, and came back the next day, I probably would have got arrested for shoplifting, something else I didn't do.
Okay.
And I have the video on my phone showing that I did not threaten anyone, but the officer still arrested me. So I don't know how you find probable cause.
Well, I went to law school. Did you?
I don't know if law school has anything to do with common sense. Like, if I can show
Do
you the
you
video-
understand what probable cause is? As opposed to beyond and to exclusion of a reasonable doubt. Probable cause means a cop could come in here and absolutely lie. And I'm just being honest with you, could come in here and write a charging affidavit and absolutely lie and say that you murdered someone. But when I read the charging affidavit, if it says that the officer saw you shoot someone and kill them, that's probable cause for murder.
Okay.
That's kind of how it works. I know you may not like it, but that's just how it works. So that's how I found probable cause, is based on what's on the 4 corners of the charging affidavit. That's why we give you an attorney, so that you can go back and fight the motions to possibly get all of this thrown out. The problem is you've got to argue this in front of Judge Steve Jewett, not me, because he's going to be your trial judge.
Okay.
But it sounds like you'll be able to help your attorney quite a bit.
I know I will. I didn't have to go to law school either.
Okay. Well, maybe you should think about it. It sounds like you might be good at it. Okay? Good luck, sir. Thank you.
The place right here, man?
Your Honor, Tariah Thomas review.
Okay. On Tariah Thomas, that's case number 2022 MM 8098. 8019AO. I am finding there's probable cause for resisting in possession of drug paraphernalia. I'll go ahead and appoint the public defender's office to represent her, and we'll stay the bonds at $500 each.
Now we'll wait.
Thank you. This would be Jerome Daniel Mills.
Yes, ma'am.
And Mr. Mills, were you born on January 9th of 1953?
Yes, ma'am.
Okay. So, Mr. Mills, it looks like you had failed to appear for trial back in October for disorderly conduct. Did you want to see if you could try to resolve this case today, or did you want to see if we can just get you out?
The offer from the state, Your Honor, was an adjudication of guilt, credit, time served, and court costs. Mr. Mills would like to accept and enter a plea of no contest.
Okay. So, Mr. Mills, can you raise your right hand for me? You swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. So I have the plea form you signed with your attorney. Any questions about any of the rights on the form?
No, ma'am.
And she said you wanted to enter a plea of no contest. Has anyone forced you or threatened you to do that today?
No, ma'am.
And do you understand if you're not a U.S. citizen, entering into a plea today could subject you to deportation?
Yes, ma'am.
Okay. And I just didn't, how many full total days served does he have?
4 days.
20? Okay.
4.
24? Okay.
No, 4.
Oh, 4. So, Mr. Mills, I'll adjudicate you guilty. I'll sentence you to 4 days in the Orange County Jail with credit for the 4 days that you've previously served. I'll release you from this charge and this charge only. The court costs on this are $223 plus a filing fee. This is a city. So a $10 filing fee and then the PD lien, but we'll go ahead and give you a full year to pay that back. If you don't pay it off in a year, they'll suspend your driver's license. If that's a concern for you, you can write to me and we'll give you some more time. Okay? Good luck to you, sir. Thank you. Next, I have Auguste Adolphe. Is that you?
It's actually Adolph August. They just wrote my name backwards. I don't know why.
Ah, okay. So it's Adolph August.
Correct.
Okay. And I think I tried to, what, are you originally from Haiti?
Yes, ma'am.
I tried to give you more the French spin to it. Is that how your family says it, or
Yeah,
no?
it is actually. It does have a French spin.
Okay. And I just want to verify you were born on June 18th of 1985.
Yes, correct, ma'am.
Okay. So I do see that you're here on this driving while license suspended or revoked, or I'm sorry, it's a driving without a valid driver's license charge. Did you want to try to resolve it today, or did you want to just try to get out and resolve it later?
I mean, I would.
So
the offer, Your Honor, from the state was an adjudication, credit, time served, and court costs, if you would like to accept the state's offer.
So what we're saying is if you want to resolve it today, you could plead to the charge of driving without a valid driver's license. They would adjudicate you guilty. It doesn't put any points on your license. It is a conviction. And then the court costs are $306. I give you a year to pay that back. Or we can talk about either the $500 bond or something else and trying to get you out of jail, and then you can resolve it later. What do you think you might want to do?
I'd like to resolve it today.
Okay. If you can, she has a plea form right in front of you. If you could sign that for me, that would be great. Now, that plea form does have the rights that you would be giving up today to enter the plea. Did you have any questions about any of the rights on the form?
You explained there would be no points or anything. So.
That's correct, yeah. Can I just get you to raise your right hand for me? Do you swear or affirm that you'll tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. Now, she indicated you could, entering a plea of no contest. Has anybody forced you or threatened you to do that today?
No, Your Honor.
And you understand if you're not a U.S. citizen, entering into a plea today could subject you to deportation?
Yes, Your Honor.
Okay. So I will go ahead and accept your plea. I will adjudicate you guilty. I'll sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've previously served. We'll release you from this charge and this charge only. Like I said, there are court costs of $306, but I'll give you a year to pay that back. If you run out of time, they will try to suspend your driving privilege, so write to me before that year runs out, and we can always give you some extra time.
Okay.
Okay, good luck to you, sir, thank you. I'm sorry?
Yeah, regarding the fees, because I'm kind of having a hardship at the moment. Is there a way that I can get like maybe a lower fee or a payment plan or something? Because I'm in the process of obtaining my license back. I just don't
Yeah.
want that to stop me or.
So this money won't be due at least for a year from today's date. But if you have other money that you owe, you can always go to the clerk's office and ask them to put everything together and put you on a payment plan.
Oh, okay. So I would still be able to obtain my license while
Yep.
paying off this payment?
Absolutely.
Okay.
It won't suspend, this charge won't suspend your license unless you haven't paid it in full by the end of a year from today.
Okay.
Okay? You're welcome, sir. Good luck.
Obtain my license.
Yeah. Oh, definitely. This shouldn't stop you from doing that.
Okay.
Okay. Good luck to you, sir. Thank you. Okay, good afternoon, sir. Are you Melvin Gomez Sosa?
Yes, that's me.
And were you born on November 29th of 2001?
Yes.
Okay. So, sir, this is case number 2022 CT 1512AW. When you failed to appear for your arraignment, they issued a capias or a warrant for your arrest for $2,000. Was this something that you wanted to try to resolve today, or do you want to just try to bond out?
Have a moment, Your
Uh-huh.
Honor. Your Honor, I just ask that you stay the bond and appoint us so we can assist him with getting his driver's license.
Sure, absolutely. So the bond will remain set at $2,000. I'll appoint the public, well, actually, hold on one second. So, Mr. Gomez, the staff in the back that helped kind of filled out the affidavit of insolvency, they indicated that you get paid weekly. Is that correct? Now, they listed that you get paid $800 every week. Is that without fail, you always get paid $800? Or does it kind of go up and down?
Up and down sometimes. I don't work every day.
Do you work, what's your job?
I do concrete and painting.
I'm sorry, you do what?
Concrete.
Concrete? So it kind of just depends on the supply and demand and what the weather's like to some degree as well? Okay. So, would you agree that you get it paid at least $200 a week without fail? Would you say that's a good general rule?
Yeah.
Okay. So I'm going to go ahead and indicate that based on the $200 a week that you would qualify for the services of the public defender. I'm going to go ahead and appoint them to represent you. Like I said, the bond amount is $2,000. The only person that can change that is the judge that issued the capias. So contact your attorney so they can possibly get you a bond hearing if you can't make the bond. Okay, good afternoon, Reginald Jenkins.
Yes, ma'am.
Mr. Jenkins, is your date of birth March 8th of 1996?
Yes.
Okay. So, Mr. Jenkins, you're here on a failure to appear for trial for a driving while license suspended or revoked. It looks like Judge Bigney set your bond at none. There's not much I can do about that. I can appoint the public defender's office to represent him.
There's an offer to resolve.
Oh,
With an adjudication of guilt, credit time served, Mr. Jenkins would like to accept the state's offer and enter a plea of no contest, as well as court costs.
okay, perfect. So, Mr. Jenkins, if you could sign the plea form down at the bottom for me.
Okay.
Can you raise your right hand? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. So, Mr. Jenkins, I do have the plea form here that you had signed. Did you have any questions about any of the rights that are on the plea form?
No, ma'am.
And they've indicated that you would like to enter a plea of no contest. Has anybody forced you or threatened you to do that here today?
No, no, ma'am.
And do you understand that by entering into a plea today, if you are not a U.S. citizen, that may subject you to deportation?
Yes, I understand.
Okay. Give me 1 second. I do have your driving history. Okay.
And we did go over that, Your Honor, and he understands.
He what? I'm sorry.
He understands about being a habitual driving offender.
Yes.
Because of all of the offenses he has.
So probably, Mr. Jenkins, the most important aspect to this just means that they may extend that 5 years out a little bit, but most importantly, what's going to affect you is you wouldn't be able to get a hardship license for at least a year from today's date.
So it's going to reset again because
It's not going to start a new 5-year period. It'll just, so like right now, I'm showing that it got, the HTO was done in March. So so you would be up in March of 2027.
Okay.
So instead, they may extend it out to November of, or December, no, today's the 30th. So November 30th of 2027. But the thing that's going to cause you the biggest problem is, but it kind of gives you a year to try to get everything done. If you can get everything like back in place where everything's paid for, a year from today, you could get a hardship license, and then those last 4 years of the HTO, you could at least drive to school, to work.
that's
grocery
all I need anyway.
Yeah.
That's perfect.
So that'll give you a year to work on that.
Okay, that's fine. Thank you.
Okay, you're very welcome, sir. So at this time, I will go ahead and adjudicate you guilty. How many days does he have total?
2 days.
I'll go ahead and sentence you to 2 days in the Orange County Jail with credit for the 2 days that you've previously served. I'll release you from this charge and this charge only. There are court costs, which includes the PD lien, and I'll give you a year to pay that back. Do you have any other questions?
Okay, perfect. Thank you.
You're very welcome, sir. Thank you. Good luck. Okay. Okay. So this would mean, this is Mr. Caraballo.
Yes, ma'am.
Okay. So, Mr. Caraballo, I know that I saw you yesterday? I think it was yesterday. So these are additional charges that were placed on you regarding the incident that occurred previously. I'll go ahead and make sure we appoint the Public Defender's Office to represent you on these cases as well. I am finding that there's probable cause. I'll go ahead and stay the bond at $3,500 on count 1. He is entitled to a bond because that's a F2. So I will go ahead and set your bond at $5,000 on count 2. And then you'll just need to comply with the other conditions of your case, which I believe were no contact with the co-defendant and no possession of weapons or firearms and no return. Okay,
And
good.
no contact with the co-defendant as well.
And no no contact with the co-defendant. Okay?
Ma'am, can I get a photo of the paper of my new charges?
I can't give you this paper. I can write it for you, but you'll have to get it from the attorney.
The victim or the co-defendant? Yeah. Shayna Echeverria. Is that you, ma'am?
Yes, ma'am.
Thank you. Everything's being recorded, so if you don't answer me, it's really kind of hard to know what's going on.
Okay.
So, you're here on a capias that was issued in 2022 CF 5633AO. It looks like when you failed to appear for a trial management conference on November 18th, Judge Calderon issued a capias. The bond amount is $50,000. I do see that Mr. Schwartz is your attorney. Does he know that you're here?
He knows, and I had a conversation with Mr. Swartz today of the tropical storm because I knew I had court, and
So Miss George doesn't represent you, but she is a public defender, and she's going to tell you, you really shouldn't tell me or the state attorney anything about the conversations you had with your attorney. I just wanted to make sure if he knew that you were here, because he needs to get you back in front of Judge Calderon if you're not able to make the $50,000 bond, to do a bond hearing with him.
I don't know if he knows or not. But my appearance was supposed to be waived, and I did not know I had a warrant for my arrest.
Okay, well, that's something definitely Mr. Schwartz needs to get you in front of Judge Calderon to talk about. So I'll make sure that he knows that you're here, and we'll move that message on to him, okay? Okay.
Yes, ma'am, thank you.
Good luck to you, thank you. Hi, good afternoon, sir. Are you Jajuan Jordan?
Jawan, yes, ma'am.
Jawan? Okay, thank you. And sir, were you born on March 30th of 2002?
Yes, ma'am.
Okay. So this is case number 2022 CF 13826AO. I did review the charging affidavit. I do find that there's probable cause. Let's do this first.
And Your Honor, as to his,
I looked at the other case. I'm not inclined to
okay,
revoke in term unless the state has some real strong feelings about it.
I have a notice.
Or not
of-
revoke in term, but revoke the bond.
I knew what you meant, Your Honor. No, state will leave it within your discretion. I don't believe there was a weapon alleged in that view, or in that.
No, I read through it, no.
State has no objection.
So, Mr. Gordon, let me ask you a question, because you do have the Public Defender's Office representing you on the case that you're currently out on pretrial release for.
closed it, Your Honor, today from what I see. That's why I was, 11:30, they filed a notice. Right.
Yes, I have a notice of revocation of pretrial release form.
Ah, okay. Is that because of discharge?
I believe so.
The state's gonna look too. If you look at the case number, Your Honor, today, it looks like it was closed from what I can see. I don't know if you have the same thing.
The DB? The charge he's out on bond? Oh, I just looked at it at lunch, but
Unless I'm seeing
The case number on the first appearance information sheet is incorrect, right? It's 5691, not 591.
Yep, and on 11:30, no information notice was filed, and it's showing closed, and that was actually today.
That is correct.
so we all agree
Today,
that that case is
11:30.
done.
It's closed.
Okay, so that's good, but I still need to go back to my original question, which is the affidavit of insolvency for today. They're saying that you don't qualify for the public defender. I did look. I think part of the problem is because that it's indicating that you get paid $2,500 every 2 weeks at your job. Is that correct?
Approximately.
But is that every 2 weeks without fail?
It's like, it's freelance, so I don't know. I just.
Okay. So, Ms. George, can I ask a favor of you? Because this is happening like quite a lot, and I don't know if you guys have somebody new back there. And believe me, I don't ever want to look a gift horse in the mouth, because I know that they help you a lot by doing this. But I think the problem is they're just asking them, how much do you make at one time? And so every time I've been asking them, it's one where it kind of goes up and down.
Yes, and I will discuss it, because I realized that this week, it's been going on, so I will have a.
And it just slows us down a lot.
Yes.
So, Mr. Jordan, I looked at, Gordon, apologize. I looked at your old affidavit and that had indicated that you made 500. So is that usually the range that you'll go somewhere between 500 and 2,500 depending on the week?
Yes, ma'am.
Okay. So, and do you have any children?
No, ma'am.
Okay. So I'm going to go ahead and change the affidavit of insolvency. That would mean that you do qualify for the public defender's office. So I'll go ahead and appoint them to represent you. So let's go back to the new case. I'm going to go ahead and stay the bonds at the 2,500 on count 1, 150 on count 2, 150 on count 3. Since the charge that you're currently on pretrial release for just got no billed or no info today, I will go ahead and take no action on that, and then you can just bond out on these new charges.
And Your Honor, state would request no weapons, firearms, or ammunition on the new law.
Yes, and no possession of weapons or firearms or ammunition. Gotta sign this, but I'm not quite sure how. I'll figure that out.
There's no weapons or firearms.
I'm hoping this will satisfy her. So on the violation of pretrial release, I just put no KP is issued because the case was no info. Is that okay? And I turn that into her? Okay, thank you. Okay, and this is Rachel Griffin?
Yes, ma'am.
And Ms. Griffin, were you born on March 12th of 1992?
Yes, ma'am.
Okay. So let's start with the affidavit of insolvency as well. I think this may pop up in your case as well. They indicated that you get paid every 2 weeks at your job. Is that correct?
Yes, ma'am.
And they said it was $2,000. Is that without fail, or does it kind of go up and down? Like every 2 weeks, does your employer hand you a check or give you cash for $2,000?
I don't even, I work at the labor pool.
So it
kind of
really just
varies.
depends, right? So when's the last time you got paid?
Like 3 days ago.
Okay. And how much did you get paid that time?
$91.
$91? Okay. And was that for a week's worth of work or just for?
Just today.
Just a day, but that was one day all you had worked in 1 week, I guess is my point.
Yes, ma'am.
Yeah,
It's like
okay.
day-to-day work.
So I'm gonna go ahead and change this because that does change what we're talking about. And you do have 2 children, so you do qualify for the services of the public defender, and I am gonna go ahead and appoint them to represent you. And then in this case of 2022 CF 13840, I am finding that there's probable cause. You are entitled to a bond on the fleeing and attempting to elude. So I'm gonna go ahead and set the bond at $1,000 on count 1. I'll stay the bond at $1,000 on count 2. And I'll reduce the bond to $100 on count 3.
Thank you.
You're very welcome, ma'am. Good luck to you. Thank you. Hi, good afternoon, sir. Are you Douglas, is it Houghton?
Yes, ma'am.
Did I say that properly?
Houghton.
Houghton. Okay, thank you, Mr. Houghton. So, Mr. Houghton, you are here on case number 2022 CF 13841. You did have a bond on there. I think per the administrative order, it was a case where you're supposed to be seen by the IA judge before you're allowed to bond out. So I am going to go ahead and appoint the public defender's office to represent you, but I will go ahead and we'll keep the bond set at what the deputy had listed, which is $2,500. And was there anything that the state wanted to add as conditions? Or anything like that? I don't know what I could,
Sometimes they do no access to social media such as Facebook, which is where I believe this alleged threat was posted. So say we just ask for no access to social media, which includes Facebook, Snapchat,
okay.
all the standard
So
social
we'll
medias.
just keep you off social media for a little while. I've done it a couple times. It's very liberating. You might enjoy it, okay? Good luck.
Thank you, ma'am.
Thank you.
Did you appoint us, Sharon?
I did, yes.
Here you go.
I recommend we all stay off
Hi.
social media. Hi, good afternoon. Is it Kiana?
Yes, ma'am. Thank you for pronouncing it correctly.
You're very welcome. And then your last name is Hudson Reynolds, correct? And you were born on November 1st of 1999?
Yes, ma'am.
Okay. Okay, so this was a capias that was issued in case number 2022 CF 5145AO. I do show that the Public Defender's Office had been appointed to represent you. It looks like the judge, when you failed to appear for a status hearing.
When?
Bond not to be modified at initial appearance. They set your bond at none. So I kind of need to get you back in front of the trial judge so that you can talk to them about that and your.
When was the court date?
It says the court date was on November 21st of 2022.
I never seen a set court date after my last time in jail.
Okay, well, let's get your attorney to get you in front of Judge Wilson, and if she agrees, I'm sure she'll let you out, but the problem is she left notes that I can't touch it. She gets very picky about that stuff.
Okay, so Judge Wilson is whom?
Judge Wilson is,
Whom?
she's gonna be your trial judge on the charges.
Oh, was she the one I saw for my first periods last time?
I hope so.
What does she look like is what I'm saying.
Petite black lady?
Oh, no, I haven't seen her.
No, I haven't seen her? Oh, you'll like her. She's very nice.
Okay, so
So-
she might let me out, is what you're saying?
Yeah, as long as you talk to her with your attorney, she'll go through that with you, okay?
When would that be?
Call your attorney and they'll get it set up for you.
I don't have a number for her.
They have Polycom right there. You can Polycom them or call them on the phone.
Okay, thank you.
You're welcome. Joseph Jermaine Jackson. Bonded? This would be Jennifer Michelle Jones. Okay. And Miss Jones, your date of birth, November 17th of 1978? Okay. So this is case number 2022 CF 13811AO. Give me 1 second to get to this. Okay, I have reviewed the charging affidavit in this case. I am finding that there's probable cause for the charges. I'll go ahead and stay the bonds at $3,500 on count 1, $100 on count 2, $100 on count 3. This is assigned to Division 16. I'll appoint the Public Defender's Office to represent you. My bigger concern is that you are currently out on bond in regards to case number 2022 CF 8608AO, which is a burglary of a dwelling.
I've been going to all the court dates.
Okay, well, that's not really my concern. My concern is that you're committing the same type of offenses. So I am going to revoke the bond that was previously entered in that case and set it at none. I do show that your attorney, Ms. Myers, with the Public Defender's Office, she can try to get you a bond hearing in front of Judge Alvaro. Okay? Good luck to you. Thank
Your
you.
Honor, the new lawsuit would request no return and no contact.
Yes, no return and no contact with the alleged victim. Mr. Joseph, how do you say your first name? I don't want to butcher it.
Luka Jael.
Say it one more time.
Luka Jael.
Okay. And were you born on June 22nd of 1996?
Yes, ma'am.
Okay. So this is case number 2021 CF 13862AO. This was a capias that was issued for failing to appear for a remand on November 22nd. The Public Defender's Office has been appointed to represent you. I would assume the DC means drug court, because I did see Judge Lattimore's name on it, and I think she's the one that issued the warrant. So your attorney's gonna have to get you back with Judge Lattimore so that they can try to, get you a bond hearing, okay? Or actually, it may be that you're just gonna be taken into custody for your sentence, okay? Good luck to you, sir. Thank you. Landon Mackey?
Yes, ma'am, Your Honor.
Mr. Mackey, sir, were you born on July 21st of 2001?
Yes, ma'am.
Okay. Let me just get to this page. Okay, so this is case number 2022 CF 1382080. I have reviewed the charging affidavit. I am finding that there's probable cause for the 3 charges in this case. While they were originally listed as no bond, you are entitled to a bond. I will also appoint the public defender's office to represent you. I'm gonna set your bond at count 1 at $5,000, count 2, $150, count 3, $100. I am gonna order that you have no contact with the alleged victims or witnesses in this case, and that you not return to that parking lot of that establishment, and that more importantly, you not possess any weapons or firearms. Okay? Good luck to you, sir. Thank you.
I have one question, if that's okay.
Yeah.
When I go to get my vehicle back, how would I approach that if I can't get near them?
I would talk to your attorney because it depends on if the police department or sheriff's department took the vehicle. It sounds like they just had it towed.
Yeah, I think it's at the first towing.
So, how about this? I'll put in the paperwork that even though you're not to have any contact with the victim or witnesses, that you're certainly allowed to go back to the towing yard to retrieve your vehicle.
Thank you.
Okay? And I'll do that, let's just say, can he return to get his vehicle with law enforcement officers? Okay.
With law enforcement?
Yeah, just make sure you call them, because in that way, nobody can say that you did anything that you weren't supposed to. All you have to do is just say, hey, I have a court order that says I can go pick up my car, but I need law enforcement to be there with me. And then they'll just show up and make sure that everything's kosher and no bad things happen.
Thank you very much.
You're welcome, sir. Thank you. Braji Godin? Are you also known as Karima Moore?
Yes.
Okay. Which one did your mom call you when you were born?
Bridget Bowden.
Braji Bowden?
Yes.
Okay. And is this the lady from yesterday that had the, okay. So you realized that there was a warrant yesterday that I took care of because I think you'd used your sister's name and she had a warrant for your arrest. So you got picked up on that. So that one went away because we figured out that that's not you, that was your sister.
Okay.
But this charge is you.
Yes.
This is 2022 CF 3846AO. It says that you failed to appear for an arraignment on May 12th of 2022. The judge issued a bond amount of $2,500. Did you want me to appoint the public defender's office to represent you, or are you gonna try to hire your own attorney?
The public defender's office.
Okay, we'll go ahead and appoint the public defender's office, and you're all set, okay? Good luck to you, thank you.
I have a question. So you're saying that my bail is $2,500?
Yes, ma'am.
Okay, thank you.
You're welcome. So the difference is the difference between a cash bond and a surety bond. It really depends on if your family can go to a bondsman and they'll let them give collateral and then they only have to pay that 10%. But you are correct. Sometimes because if they're out of state, they want them to pay either a larger amount or they want them to pay all of it up front. That's just something between your family and the bondsman, though. I'm not completely sure about that.
So basically, if I don't have anything like collateral,
Yes, ma'am.
But can she be allowed to return home, Your Honor? Because she just stated she was out of state. I didn't.
Yeah, where do you live?
I live in Delaware.
Oh, that's right, because you said you were trying to get home. So yeah, I'll indicate that the court has no objection to you returning back to the state of Delaware if you're able to get out. Just make sure you maintain contact with your attorney, okay? Yeah, talk to your attorney, and then they can also give you some stuff where you put in your cell phone number, and they'll send you dates. I think it might be on that paperwork. You're welcome. Okay, Christopher J. Nahart. Okay, Mr. Nahart, you were born August 21st of 1957.
Yes, ma'am.
So I have you here on 2022 CF 4855AO. This looks like when you failed to appear for your trial on November 1st, that judge issued a warrant for your arrest. They set your bond at none. Now, you do have the public defender's office appointed to represent you, so they can try to get you back in front of that judge for a bond hearing, or maybe try to get you back on the trial docket. Okay? Good luck to you, sir. Thank you. The next case I have is Juan Antonio Paleza Zaga. Bonded. How about Reginald Reed? Okay, Mr. Reed, good afternoon. Were you born August 13th of 1997?
Yes, ma'am.
Okay. So were you wanting to try to see if the public defender's office could be appointed to represent you, or are you gonna hire your own attorney?
I was just gonna plead guilty to it, for what I got charged with.
Wait, say that one more time?
I'll take a public defender.
Okay, so let me ask you a question. Are you currently working?
Yes, ma'am.
And it's from the paperwork that they listed, it sounds like you get paid at your job every week. Is that correct?
Yes, ma'am.
Okay. She put that you get paid $600 every week. Is that without fail, no matter what, you always get paid $600 a week,
No,
or does
no,
it
ma'am.
sometimes go up and down?
It varies.
Okay. When's the last time you got paid?
I've been working the last 3 days because the last time I got paid was Friday.
Okay. How much were you able to bring home that day?
I think like $200 and some dollars.
Okay, that's much. So let's do that. So based on the 200, I will go ahead and note that you do qualify for the public defender's office. We're going to appoint them to represent you. So this is 2022 CF 13836AO. I did review the charging affidavit. I am finding the probable cause for the charges. I will stay the bond amounts at $1,000 on count 1 and $100 on count 2. I am going to order that you have no contact with the co-defendant in this case, Travis Daniels. And you're all set, okay?
Your Honor, he qualified for pretrial release.
Oh, he does. I'm sorry. I was looking at the guy that bonded out. He does qualify for pretrial release. So I'll go ahead instead, release him on pretrial release, the conditions that he have no contact with the co-defendant. I am going to add, though, that he not possess any illicit substances, and can be, and will be drug tested randomly to make sure that he's abiding by that. Okay? Good
Do
luck.
you have a 30-day grace period, Your Honor?
Oh, yeah. Let's not test him for at least 30 days. Jan Sanchez?
Yes, good afternoon, man.
Hi, Mr. Sanchez. Were you born on May 1st of 1993?
Yes, ma'am.
So let me ask you a question. Were you wanting the public defender's office appointed to represent you, or were you going to try to hire your own attorney?
Yes, public defender.
Public defender? So do you get paid at your job every 2 weeks?
It varies. It's 2 weeks or bi-weekly at times.
Okay, so when was the last time you got paid?
Friday.
Friday? And how much, after they took out taxes and everything, how much were you actually able to bring home?
This time it was around like $960.
Okay. I'm gonna put that, and you have 2 children, correct?
3, well, one on the way also.
Okay, okay. Well, congratulations. Well, I will go ahead and, based on the information you've provided to me, you do qualify for the public defender's office, so I'm gonna go ahead and appoint them to represent you. I did review the charges in this case in 2022 CF 138 62AO. So I'm gonna stay the bond amount on the trafficking charge. It is $100,000. I will go ahead in the 2022 CT 6745. I'll lower the bond to $100, and to 2022 CT 6746 AO, I'll lower the bond to $100. But the PD will represent you on all the cases. Okay, good luck to you, sir. Thank you.
Standard amount.
Okay, Shauna Shirey,
Yes, ma'am.
and were you born August 2nd of 1975?
Yes, ma'am.
Okay, thank you. So ma'am, I reviewed the charging affidavit in case number 2022 CF 13822AO. I am finding probable cause for the charges. It's assigned to Division 22, and I'll appoint the Public Defender's Office to represent you. I am gonna stay the bond at $2,500 on count 1, $2,500 on count 2. I'll lower the bond to $2,500 on count 3, and $2,500 will be stayed on count 4. Okay, good luck to you, ma'am. And I am also going to order that you not return to that bank, which was the McCoy Federal Union.
Your Honor, Steve would also ask for no contact with the co-defendant.
No contact with the co-defendant. I got the impression she might not recognize him again, but we'll see. So just no contact with the co-defendant. I can't imagine that you want to hang out with him anyway. So, okay, good luck. Thank you.
Judge, the next defendant has a victim.
Okay, and that would be Stephen Seeger. Hi, good afternoon, sir. You're Stephen, is it Seeger? Is that how you say your name properly?
Stephen Seeger, yes, ma'am.
Okay, and you were born October 29th of 1962?
Correct.
Okay. I'll come to you in just one second. So let me ask you a question. I noticed that in the affidavit for the arrest warrant, it had indicated maybe that Andy Chemelier had represented you in the past. Were you going to try to have Mr. Chemelier represent you on this case, or did you want to see if you qualified for the public defender?
No, he already received a call yesterday, voice messages, and then calls today from me on his voicemail and others. So he's aware, but it was all last minute.
No, I understand, but it's your intent that you'd like for him to continue to represent you.
Correct.
Okay, so, because right now it looks like you don't qualify for the public defender, so I'm just going to go ahead and pull it out since Mr. Chemelier will probably get in touch with you as soon as he can. And I'll follow up with him too, just to make
Yes.
sure.
Do you need his number?
Nope, I have his number, but thank you. So let me inquire, ma'am, can you raise your right hand for me? Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
And can you tell me your name?
Mary Black.
Okay. And Ms. Black, I did read the charging affidavit in this case of 2022 CF 13562AO. This is an arrest warrant that was signed by Judge John Beamer, so he determined that there was probable cause. It's assigned currently to Division 12. Now, Ms. Black, if it's my understanding, you and the defendant are ex-boyfriend, girlfriend, correct?
Correct.
And you have this injunction. What was it that you wanted the court to know? Other than you have the injunction and you would like for him to abide by it?
Yes, and he hasn't.
Okay.
He has violated. And I don't feel safe.
Okay.
For myself or my family.
Okay. And Ms. Black, without talking about the facts of the case, I do have to tell you an injunction in theory is really just a piece of paper. How it becomes a tool for you to use is that every time you feel like he violates the injunction, you do need to call the police and let them know. Not saying that you haven't done that, but I'm just saying that's really what gives the injunction its teeth, so to speak. And Mr. Seeger, I don't want to talk to you about the facts of the case or anything else, but understand that this injunction is in place, and every time you violate it in some way, shape, or form, you do run the risk of coming back to jail. At some point, if this continues enough, you won't be entitled to a bond at all. So I just want you to keep that in mind. Now, you are entitled to a bond today. Is it my understanding he's currently in jail on these other charges as well? Or are they just pending? I'm seeing there's like, oh, that's a different person. I apologize. I need to keep up with my paperwork. I apologize. You thought I was crazy, didn't you? Sorry.
No, ma'am. No, no, ma'am.
Okay.
I was about to faint.
No. So, sir, I am gonna go ahead and give you a bond. The bond's gonna be $5,000. Obviously, I have to require you to abide by your injunction, but I'm also gonna have you sign a no contact order that goes along with this case. I'll get one if the officers don't have one. But what that really entails, sir, is that if you have contact with her, not only are you running the risk of getting new charges filed against you, but you're also running the risk of ending up back in jail for violating the conditions of this release.
That is correct. Yes. I have one question.
Yes.
Her name was never mentioned in any of the paperwork I received, so I made an assumption, but I don't even know what I did. And I was at a business meeting with 1,000 people when they arrived. I don't even know what I did to curb not to do it.
Okay, well, I don't want to discuss the facts with you on the record, mainly because the state is present. You definitely have Mr. Chemalier, and he's going to be subject to all of the discovery. So it's not going to change anything that I would do today because another judge already found probable cause. So you would really need to talk to him and let him try to work that out with you, okay? But I am going to have you sign the no contact order. And then the bond will be $5,000. I'll also obviously order that you abide by any injunctions in place and that you also not possess any weapons or firearms.
May I ask about the bond? Can I pay that in full today myself, so I don't?
Yes.
And in the items they have from me, when they took me at a hotel meeting in public, 1,000 people, it was embarrassing. But everything's at the hotel. My wallet, my car keys, everything.
I don't have a problem with
I do have a debit card with $10,000 on it, and I'm not sure the process. Will someone help me with that when I leave?
They'll talk you through that. Yes, sir. Okay. Ms. Black, was there anything else that you wanted me to know?
Yes, I would like to know, is there any way he can be monitored?
I wish. We used to have electronic monitoring, and we got rid of it probably about, I think it was like 2010, and it's never come back. And I've never really gotten a strong answer for why. I know that other counties do have it. I will tell you, though, that there's problems with it as well, because a lot of times that people know how to manipulate the monitoring systems, and even though you might have the box that would tell you if he comes within a certain range of you that would go off, sometimes it's wrong. So that's why I said it's unfortunately, it's really your position to be vigilant to make sure that you feel safe. And if you don't feel safe, contact the state attorney's office, or first of all, contact law enforcement immediately, but then reach out to the state attorney's office and talk to them about maybe there are things that they could do to help you with that.
Okay, thank you.
You're very welcome. Good luck. Good luck to both of you. Thank you. Okay, good afternoon. Are you Charles Small?
Yes, ma'am.
Mr. Small, you were born on October 1st of 2003?
Yes, ma'am.
Okay. So in case number 2022 CF 13824AO, I did review the charging affidavit in this case, and I gotta tell you, it kind of was confusing. So do you agree, and do you want me to get some more information? Because it says burglary of a dwelling, and then he talks about, well, all I can talk about, I guess what's confusing to me is he talks about that he's at a barber shop, and I don't expect you to respond to anything, so don't worry about that.
Yes, ma'am.
So he's at this barber shop, and then they say they see him taking off running. I'm assuming what they're trying to say is that at one point while he was running, that he went into somebody's yard. But it seems like the deputy was so concerned about telling me what the pedestrian violation is, which really don't understand how that has any thing, that, he talks about that, but because then he says, entered an enclosed fence curtilage of residential property, but I have no idea where this is.
Our state will request 24 hours.
Okay, so what I can do, Mr. Small, is I'll go ahead and stay the bonds on the cases at $5,000, $2,500, $500, and $250. I'll appoint the public defender's office to represent you. You're still more than welcome to go ahead and try to bond out between now and tomorrow, but I am gonna have the state come back tomorrow and try to give me some more information. It could be that if they can't provide that information for me, some of these charges will either go away or the bond amounts would at least change.
Yes, ma'am.
Does that make sense?
Yes, ma'am.
Okay, good luck to you, sir. Thank you.
Yes, ma'am. Thank you.
You're welcome. Maurice Daniel Smith.
Yes, ma'am.
Mr. Smith, your date of birth is December 5th of 1998?
Yes, ma'am.
Okay. So, this is case number 2022 CF 13648AO. Judge Beamer signed off on the, Judge Denise Beamer signed off on the the probable cause. So she has it, the probable cause on this case. I will go ahead and appoint the public defender's office to represent you. You are entitled to a bond. I am gonna set your bond in the amount of $5,000. I am gonna order that you have no contact with your uncle at this time and that you not possess any weapons or firearms.
Yes, ma'am.
Okay, good luck to you, sir. Thank you.
Thank you.
Okay. Next, I would have Uriel Thompson. Mr. Thompson, good afternoon. Were you born December 18th of 2003?
Yes, ma'am.
So, sir, I did review the charging affidavit in this case, which is 2022 CF 13838AO. I am finding that there's probable cause. It does look like you qualify for pretrial release. I am going to appoint the public defender's office to represent you. I'll go ahead and release you on pretrial release with the conditions that you not possess any weapons or firearms and that you not possess any illicit substances. And I think that's it. Was there anything else from the state that they wanted?
No, Judge.
Okay, you're all set, sir. Good luck to you. Thank you.
All right, thank you.
Alexis Torres.
Yes, ma'am.
Hey, Mr. Torres. So they added another charge on to what we talked about yesterday. This is in 2022 CF 13814AO. I'll go ahead and appoint the public defender's office to represent you. They've charged you with aggravated assault with a firearm. I am finding probable cause. However, I'll set your bond at $2,000 with the conditions that I previously indicated, but most importantly, no contact with the alleged victim in this case or the co-defendant, Mr. Caraballo.
Yes, ma'am.
Okay, good luck to you, sir. Thank you. Mr. Wilson,
Yes, ma'am.
how do you say your first name? Is it Ramis?
Yes, ma'am.
Okay. And were you born on February 22nd of 2002?
Yes, ma'am.
Okay. So, sir, I did review the charging affidavit in this case. That's in 2022 CF 13833. I am finding that there's probable cause. This is assigned to Division 14, and I'll go ahead and appoint the Public Defender's Office to represent you. let's see here, there we go. I'm gonna go ahead and stay the bond at $5,000 on count 1. I'll reduce the bond to $100 on count 2. I am gonna order that you have no contact with the alleged victim in this case, Mr. Hall, and that you, yeah, I'll just leave it like that. Plus, do not possess any weapons or firearms,
Yes,
okay?
ma'am. That's what I was gonna add. They told me to write a statement, and I was telling them I was helping him, not.
Don't say anything to me, only because you're being recorded and everything you can say can be used against you. I would talk to your attorney about any statements that the police wanted you to write, because they may be using that to try to help you reduce your sentence or something, but that's really more of a legal thing. Did you have any questions for me about when you get released?
Yes, ma'am.
Or were you more interested in about talking to the law enforcement?
Both.
Both? So I think he's saying that law enforcement had asked him to write a statement, and I told him not to talk to me about that. But can you ask him if he has any other questions?
Thank you, Your Honor.
Okay. Any other questions, sir? Okay, you're good to go. Thank you. Good luck.
Your Honor, I'm sorry.
I gave him a bond of, I did $5,000 on count 1, and then I think I reduced count 2 to 100. Okay. Oh, I wanted to ask him about hanging out in the jacuzzi.
I will waive the appeal.
Okay. So I'll go ahead. This is in case number 2022 CF 13812AO. I'll appoint the public defender's office. I'll find probable cause, staying the bonds at 5,000 on count 1, 150 on count 2, and no return to that location. And then I think we have good news for him.
Is one there?
I'm sorry, Your Honor.
Do we have good news for him?
Yes.
So, yes. May I approach?
Yeah.
So, over the break, I did speak to the ASA, and tried to get more information from her. She was able to reach out to probation, and get permission to mark it as revoked. So he is officially off probation on the DOC website as well, so he shouldn't be picked up again unless he gets put on probation again. So this one should be officially closed. It is closed with probation. He said it'll hit the DOC website. It's not immediate, but it should be whenever the system updates, which I don't know if it does like nightly updates or something. So he is officially off. That has been confirmed by his PD and the ASA in that division. So that is good. So on the on-view VOP, state is requesting that you find no PC as he was not on probation and ROR him. With probation already being revoked, it will effectively just close it. So state's requesting no PC and an ROR. And I believe Mr. Jones is requesting a offer on his trespass case that he previously didn't plead to due to this VOP.
Yes.
So can I have 1 second to look at that?
Yeah, absolutely.
I don't think he can. It's not IA anymore. It's not initial appearance and it's not filed. The admin order says only when they're here for initial appearance within 24 hours. Can we do an offer without there being a?
I can go back and say it's a continuation of his initial appearance.
I guess that would circumvent. Do you understand what I'm saying?
Mhm.
The admin order says only within that.
I think
That
that
works.
because of all the extenuating circumstances, that I can indicate that this would be an extenuation of the initial appearance, because we brought him back to inform him that he did not have the violation of probation, and therefore he can resolve the case at IA. We just moved it to a different day.
Okay.
I can do pretty much anything that's illegal as well. I mean, not that we're doing illegal things, but I mean, even if we all agree to it, that's really what needs to happen, as long as you're comfortable with it.
I just think my system's gonna kick it out because it's not an IA. The system might not let me do it because it's not.
I bet Mr. Smith could fix it for you, though. He's good like that. He wanted to try to get rid of all of my VOPs one day. I was like, Mr. Smith, you haven't been in the courtroom in a long time. It doesn't work that way. In the alternative, I could agree to release him on ROR, and then that way he can get with his attorney and try to resolve it once it's been filed on.
He has no failures to appear, so state wouldn't object, given the circumstances.
That may be easier, just to, so it doesn't cause glitches.
My system would kick it back and then it wouldn't.
We saw him Monday?
Yes. I believe it was a quick stop, if I'm not mistaken.
That one's gonna be in my division. So you could also reach out to Rebecca Addison. She's been filing most of the misdemeanors in my division. What do you think, you guys? I don't know that she's gonna be able to, she's afraid that it's gonna kick back on him. So I can do an ROR. He would have Ms. Altawam as his attorney. As long as he stays in contact with her, then we can always bring him back if he wants to plea, or just do an ROR until then. I mean, it seems like he's been pretty good about coming to court, so.
Yeah. Yep, I was just explaining that, Your Honor. ROR.
Okay, so what I'll do in case number 2020 CF 52960, that was the on-view violation of probation. Based upon the state attorney, I am going to ROR him from the violation of probation. It's my understanding, because the system now does show that you're permanently revoked from probation, that'll probably be the end of that. As to the new law violation in 2022 MM 7972AO, I'll go ahead and instead of having the bond amount, we'll give you an ROR. When you get out of jail, it's going to tell you when to come back to court for your arraignment date. Just make sure you contact Ms. Altawam. She's going to be your attorney, and she can waive your appearance at arraignment, so you don't have to keep coming back to court unless you decide you want to resolve it that day. Okay? Do you have any questions? It may have been that I thought that he had the PD original. You know why I did that? It's because she signed it. So I assume when she signs them that, not necessarily. Okay.
And Your Honor, I do have the order for the extension of 40 days.
Yes.
May I approach?
Yes, thank you.
And it was on
Yep, I have that. So I will go ahead and sign that order. And that will, I believe that we said that that date would then move out to December 7th. Okay, that was everything for today. We will be adjourned till tomorrow morning.
What are you here for? I'm here on Eric Smith, 22.
Okay, so we have a Spanish-speaking victim on that one, so we're gonna do that one. We'll do Sisley, then we'll do Smith. Go through the translator cases, to out-of-counties, to warrants, to new cases, to resets. So Smith will go second. We're gonna do Sisley first, and then Smith will be second.
Okay, thank you, Ron.
All right. So Eric Smith, where is he in the pile?
Your Honor, I also want to waive the reading.
Okay, well, hold on, wait, it's not. All right, we got a problem. My panel just went to Francesca.
He's about to go.
Francesca.
He's about.
You gotta unplug my panel because it went bad. You gotta unplug my panel. Oh, never mind, it came back. This thing goes bad every like 10 minutes.
If you have problems, let me know.
Yeah, so the way to fix it, we unplug it and we just plug it back in. You don't need to call IT, but right now it's fine. Yeah, but let me break up. Where's Eric Smith in the pile? Oh, there he is. All right, and then Sisley. All right, hold on. All right. I'm sorry. What's your name, ma'am? You're muted.
Caridad Acosta for the Public Defender Office.
Costa?
Caridad Acosta.
Acosta. Okay. Okay. Do you anticipate any PC challenges today?
Yes, Your Honor.
All right. If you tell me the case.
I have the first one in the list. I have Anderson Hezekiah.
Okay. All right.
And I have Figuereo Rivera Eduardo.
All right. All righty. All right, so I don't know if you heard me before. The order we're going to go in is Sisley, then Spanish interpreters, then out of county, then warrants, then new cases.
Yes, Your Honor.
All right. All right, so let's go. On the record, it is Wednesday, November 30th, 2022. We're here for initial appearances in Osceola County, Florida. I'm Judge Madrigal. I'll be presiding today. Let's go ahead and get appearances for the record. We'll start with the state of Florida.
Rachel Kleinpeter on behalf of the state of Florida.
Caridad Acosta in behalf of the Public Defender.
Patricia Jenkins, PTR.
All right, and the first case we'll call is Matthew Sisley. All right, sir, your name and date of birth, please. Microphone appears to be muted.
No, it's not, Your Honor. Can you hear me?
I can hear you, but I can't hear him.
Matthew Sisley, 5/10/2001.
All right, Mr. Sisley. Did you say you wanted to waive the readings on one of them, Mr. Costa?
Yes, Your Honor.
On which one?
I only have him charged as one count right now, Your Honor.
I know, I have.
I was mistaken, Your Honor. We can do the
Okay.
reading of the charges, yes.
Okay. Mr. Sicily, you're here on one count of aggravated battery with a deadly weapon. I am going to appoint Ms. Costa in her office to represent you on this case. Ms. Costa, I don't know if you're aware, the state's filed a motion for pretrial detention here today.
No, Your Honor.
Your Honor, the state has made Public Defender Crystal Broadway aware via ASA Danielle Pennell. State has filed pretrial detention to be set before Judge Young.
All right. So I'm going to hold him no bond. It'll be set for pretrial detention. This is a condition, just in case. No return to scene, no contact with any victims or witnesses, and no weapons of any kind.
Your Honor, do you find PC?
Yeah, I find probable cause. Thank you. Thank you. All right. Next one I got is Eric Smith.
Thank you, Your Honor.
Thank you. And so we have
Good afternoon, Your Honor. This is Laura Bretaña, certified Spanish interpreter, previously sworn.
Okay, Lauda. First case we have is 22 MM 2563. Right, and only our victim is the one who needs a translator. Okay.
Okay.
All right. All right. Good afternoon, sir. Your name, or sorry, appearance for the record. All right, sir, just give me your name and date of birth, please.
Good afternoon, sir. Eric Smith, 9/1981.
All right, Mr. Smith, you're here on one count of domestic battery. It's pursuant to a warrant. So another judge has already found probable cause. We're here to discuss your conditions of release. Mr. Mullins?
Your Honor, if I may, I'd ask the court to look over the affidavit of arrest. There is a probable cause to believe that a battery was committed, but not that a domestic violence was committed, because there's no domestic relationship that's alleged in the affidavit. There's no family or household member designation that's apparent from this report.
Okay. Ms. Kleinpeter?
Your Honor, a prior judge has found PC. This is initial appearances. It's inappropriate to raise a PC challenge at this time. That is more appropriate for an adversarial preliminary hearing before the trial court judge.
Yeah, Judge Beamer already had found probable cause for the domestic battery. So do you want to be heard on the bail?
Yes, Your Honor, we would.
All right.
Is the witness available now to testify?
The witness is here, but I'm not going to talk to her about bail. I'm going to talk to her about conditions of release.
Well, there's an address on here. I just want to make sure that his home address, it says 2603 Chatham Circle. That's, I understand, not where the incident occurred. It occurred at a different address, which was here, 1324 North John Young Parkway. We would ask the court to set bond in the amount of $500 on this offense, and if the court orders it, it says right on the warrant that no weapons or firearms, no contact with the victim, no return to the scene. The scene being 1324 North John Young.
I would change the conditions to no contact, maintain separate residence.
Okay, very good.
Yeah, because I think there's a little bit of confusion about where things originally happened. There's some movement.
I wanted to point that out, that's all. It's
Okay.
got the address on the top, but that's different from where it's alleged to have occurred.
All right. Ma'am, do you want to address the court, ma'am?
Señora, ¿usted desea dirigirse al juzgado?
That's the translator. Just speak in Spanish. Do you want to address the court?
Es la intérprete, señora. Habla en español. ¿Usted desea dirigirse al juzgado?
So do you want to tell me something?
¿Desea decirme algo?
O sea, sí
No.
quiero hablar, pero o sea, la pregunta que me están preguntando es si yo sigo hablando con él.
I apologize, Your Honor, but I can barely hear her.
Yeah, you need to get closer to the microphone.
Señora, acérquese al micrófono, por favor.
They can't see you, they can only see me.
Ellos no la pueden ver a usted, solamente me pueden ver a
They
mí.
can hear you, so it's important that you get close to that microphone.
Pero sí la pueden escuchar, por eso es que es importante que se acerque al micrófono.
You don't have to tell me anything if you don't want to.
Si usted no desea, no tiene que decirme nada.
The Florida Constitution gives you the opportunity to tell me something if you want to.
La Constitución de la Florida le concede a usted la oportunidad de decirme algo, pero eso es si usted quiere hacerlo.
But it doesn't force you to do it. So if you want to tell me something, I will hear you out.
Pero eso no la obliga. Si usted desea decirme algo, yo la voy a escuchar.
But if you don't want to tell me anything, that's okay as well.
Pero si no quiere decirme nada, eso también está bien.
So would you like to say something?
Así que entonces, señora, ¿desea usted expresarse, decir algo?
Yo contestar lo que me quiera preguntar, señor juez.
I will answer whatever you want to ask me, Your Honor.
Okay. Honestly, I don't have any questions.
Para serle franco, no tengo ninguna pregunta.
State?
Fiscalía.
Do you want contact with Eric Smith?
Señora, ¿usted desea tener contacto con Eric Smith?
Si quieres tener algún contacto con Eric Smith. No sé qué decir.
She has no other questions.
I don't know what to say.
I don't have any other questions, Your Honor.
No tengo más preguntas, su señoría.
Mr. Mullins?
Licenciado Mullins.
I'm sorry, her name is, Ms. Bernal?
Disculpe, el nombre suyo es la señora Bernal.
Sí.
We didn't swear her in.
Yes.
Okay, Ms. Bernal.
We didn't swear her in. Hold on, we didn't swear her in.
Un momento, que no le hemos tomado el juramento.
Can you raise your right hand for me, please?
Señora, por favor, levante la mano derecha.
You swear a firm testimony you're about to give in this matter will be the truth, whole truth, nothing but the truth, so help you God?
Señora, jura y promete que el testimonio que va a prestar será la verdad, solamente la verdad y nada más que la verdad. ¿Lo jura ante Dios?
Sí, señor.
Yes, sir.
All right, sorry, Mr. Mullins?
Licenciado Mullins.
Ms. Bernal, are you now or have you ever been married to my client?
Señora Bernal, ¿ahora mismo usted está casada con mi cliente o en alguna ocasión ha estado casada con él?
No, señor.
No, sir.
Are you related to Mr. Smith by blood or marriage?
¿Usted tiene alguna relación, ya bien sea sanguínea o de matrimonio, con el señor Smith?
No, yo no estoy casada con él.
No, I am not married to him.
Have you ever resided together as if you were a family?
¿En alguna ocasión ustedes han convivido como si fuesen una familia?
Sí.
Yes.
Okay, and you say you lived together with him as a family?
¿Y usted dijo que ustedes convivían juntos como una familia?
Sí.
Yes. ¿Por cuánto tiempo?
Más de un año.
More than a year.
You lived together with him on a full-time basis more than a year?
Así que ustedes vivieron juntos a tiempo completo por más de un año.
Sí.
This isn't a discovery deposition. She's answered the question, so we can move on.
Esto no es una deposición de descubrimiento de prueba. Ella ya contestó la pregunta. Vamos a proceder.
That's all I have, Your Honor. I would just ask the court to impose a $500 or a set bond in the amount of $500 and not to impose conditions of pretrial release.
Su señoría, esas son todas las preguntas que tengo. Le voy a solicitar a este juzgado que imponga una fianza de $500 y que no imponga las condiciones del programa de libertad provisional.
Okay, I am going to set bond. I'm going to set bond in the amount of $15,000. Order no contact with the victim. No, to maintain separate residence. No weapons, firearms. That'll be it.
La fianza es de $1,500. Se le prohíbe todo tipo de contacto.
No, 15,000.
Oh, Thank you, Your Honor. La fianza es de $15,000. Se le prohíbe todo tipo de contacto con la víctima. Se le prohíbe la convivencia y se le prohíbe la tenencia de todo tipo de armas y armas de fuego.
Thank you. Thank you, Ms. Mullins. All right. The next one I have is Yomar Nieves Rodriguez.
President approaching, Your Honor.
All right. Good afternoon, sir. Your name and date of birth, please.
Buenas tardes, señor. ¿Cuál es su nombre y su fecha de nacimiento?
Yomar Nieves Rodríguez, de 1919, julio 19 de 1991.
Yomar Nieves Rodríguez, July 19, 1991.
All right, Mr. Nieves Rodriguez, you are here on 3 counts. Possession of marijuana,
Señor Nieves Rodríguez, usted se encuentra aquí, está acusado de 3 cargos. El primero, tenencia de marihuana.
second one is possession of cocaine,
Segundo, tenencia de cocaína.
third one is possession or use of drug paraphernalia.
Y el tercero, tenencia o uso de instrumentos para el uso de drogas.
All right, I'm going to appoint Ms. Acosta and her office to represent you on this matter.
Se designa a la licenciada Acosta y a la oficina de ella para que les representen en este asunto.
He does qualify for direct PTR?
Yes, sir.
¿Cumple con los requisitos del programa de libertad provisional? Sí.
I'm going to release him direct PTR.
Se pone en libertad bajo el programa de libertad provisional.
I'm additionally going to order you not to possess or consume any drugs or controlled substance without a valid prescription.
También se le prohíbe el consumo y tenencia de drogas sin receta válida.
All right, thank you, sir.
Gracias, señor.
Thank you, Your Honor.
Thank you.
I think that's the last Spanish one I had.
Your Honor, also Rodriguez Santana Jennifer.
Okay.
She's present and approaching, Your Honor.
All right, bring her on up. Just 1 second. All right, I found her. All right, good afternoon, ma'am. Your name and date of birth, please.
Buenas tardes, señora. ¿Cuál es su nombre completo y su fecha de nacimiento? Jennifer Rodriguez, 9/18/1996.
All right, Ms. Rodriguez Santana, you are here on 1 count of trespass.
Señora Rodríguez Santana, usted se encuentra aquí ante una acusación de entrada ilícita.
I'm going to appoint Ms. Acosta and her office to represent you on this case.
Se designa a la licenciada Costa y a la oficina de ella para que les represente en este caso.
I'm going to find probable cause for that charge.
Se determina que existen indicios de criminalidad para tal acusación
I'm going to release you direct PTR
y se le pone en libertad bajo el programa de libertad provisional,
with the added condition of no return to the scene.
con la condición adicional que se le prohíbe regresar a la escena del ilícito.
All right, thank you.
Gracias.
All right.
Your Honor, there's one more.
Oh. All right.
The name is Mercado Ildefonso Joel.
Mercado Ildefonso. All right. Good afternoon, sir. Your name and date of birth, please.
Buenas tardes, señor. ¿Cuál es su nombre completo y su fecha de nacimiento?
Joel Ernesto Mercado, 12/20 del 2000.
Joel Ernesto Mercado, 12/20/2000.
All right, Mr. Mercado, you are here on a warrant for a violation of probation.
Señor Mercado, usted se encuentra aquí ante una orden de arresto por incumplimiento con el régimen de libertad vigilada.
I'll appoint Ms. Acosta and her office to represent you.
Se designa a la licenciada Costa y a la oficina de ella para que les represente.
Yes. It does. On the VOP or on the underlying?
On the VOP.
Just go. Do you have an attorney, sir?
Señor, ¿usted tiene abogado?
Sí, su señoría.
¿Qué dijo?
Sí, su señoría.
Yes, Your Honor.
Have you retained that attorney for the violation of probation?
¿Ya usted contrató a ese abogado para la acusación de incumplimiento con el régimen de libertad vigilada?
Yo la contraté para todos mis casos.
I hired her for all my cases.
So she's not here.
Ella no se encuentra aquí.
Do you want to proceed without her, or do you want to reset and see if she shows up tomorrow?
¿Usted desea proceder sin ella o prefiere que aplacemos esta audiencia para mañana a ver si ella se presenta aquí mañana?
Que la aplacemos para mañana.
I would rather wait until tomorrow.
All right.
He does have a BOP arraignment for the 7th.
He wants his initial appearance tomorrow.
Reset for
We'll reset. We'll reset 24 hours. All right. Thank you, sir.
Gracias, señor.
Thank you.
Thank you.
Now, can you make an announcement, Laura, to see if anybody else?
Yes. ¿Alguna de las personas que permanece en la cárcel necesita los servicios del intérprete al español?
Yes, Your Honor, there's one more. His name is Rodriguez Chévere. Rodriguez Chévere Isocan.
Yesterday. Yeah, it's added charge. I remember the last name. All right. Afternoon, sir. Your name and date of birth, please.
Buenas tardes, señor. ¿Cuál es su nombre completo y su fecha de nacimiento?
13 de agosto del 87, Isocam Rodríguez Chévere.
August 13, 1987, Isocam Rodríguez Chévere.
My birthday is August 14th.
Yo cumplo el 14 de agosto.
I'm going to appoint Ms. Acosta to represent you on one count of petty theft.
Se designa a la licenciada Acosta para que les represente ante una acusación de hurto de menor cuantía.
I'm going to find probable cause for that charge.
Determino que existen indicios de criminalidad para tal acusación.
Set bond at $500 and order no return to the scene.
La fianza es de $500 y se le prohíbe regresar a la escena del ilícito.
All right. Thank you, sir.
Gracias, señor.
Thank you, Your Honor.
Now is that the last one?
Yes, Your Honor, this is the last one.
All right. Laura, thank you.
Thank you, Your Honor.
All right, take care. All right. The next one I have is Jeremy DeWitt. I have two cases.
This is out of county.
Morning, Your Honor.
Morning, sir. Your name and date of birth, please.
Jeremy Charles DeWitt, 21080, sir.
All right, Mr. DeWitt, you're here on two out-of-county warrants, both out of Orange County, Florida. So another judge has already found probable cause. Set your bond at $0. I will stay the bond on both those cases. We'll let Orange County know. They'll come get you.
Roger. Your Honor, if you possibly can, I'm sorry, I know it's outside of your wheelhouse, but my wife has COVID and I have a 2-year-old daughter. If there's any way you can expedite the transfer so I can get there sooner to get home sooner, that would be much appreciated.
It's only one county away. We'll let them know.
God willing. Thank you, Your Honor.
All right. Thank you. All right. Antoine Francis.
Present and approaching.
All right, we got 4 cases. All right, sir, your name and date of birth, please.
Antoine Francis, September 22nd, 2001.
All right, Mr. Francis, you're here on 4 cases. The first one is for a failure to appear at arraignment. The second one is for a violation of probation. The third one is a warrant case for trespassing, tampering with physical evidence, I'm sorry. And the last one is also a violation of probation warrant. I'm going to appoint Ms. Acosta's office on all those cases. On the first case, and probable cause has been found in all those cases. On the first case, the judge set your bond at $0, so I'll stay that bond. On the second case, which is a VOP, the judge set your bond at $5,000. I will stay that bond. On the third case, the judge set your bond at $2,500. I will stay that bond. And on the last case, the judge set your bond at no bond. I will stay that bond.
For 22 CT 2534, jail arraignment December 8th, 8:05 a.m., courtroom 5B, arraignment January 10th, 9:30 a.m., courtroom 5B. For 22 MM 599, BOP arraignment January 5th, 8:15 a.m., courtroom 4A. For 22 CF 2850, on demand. For 20 CF 2987, BOP arraignment December 6th, 8:30 a.m., courtroom 4F.
That was good. All right, thank you, sir.
Thank you, Your Honor.
The next one I have is Luther Funches.
President approaching.
All right, afternoon, sir. Your name and date of birth, please.
Good afternoon, Luther Funches, 9783.
All right, Mr. Funches, you're here on a warrant for violation of probation. Another judge has already found probable cause. Set your bond at 0. I will stay that bond, and I will appoint Ms. Acosta's office to represent you.
Your Honor, give me one more.
Your Honor, he has a private attorney.
He does, on the VOP?
Yes, sir. Caleb Rowland is his name.
Okay, so I'm gonna make you the same offer as the last guy. You wanna wait till tomorrow? You already kinda heard what's gonna happen.
Your Honor, his VOP arraignment,
He
Oh,
wants to
he
reset
might-
for tomorrow.
He wants to reset till tomorrow.
Okay.
All right, so we'll reset till tomorrow. Hopefully your attorney will be here.
Thank you, Your Honor.
Thank you. All right, Christian Stobner.
President approaching.
Sir, your name and date of birth, please.
Christian Stabner, 09/10/2001.
I apologize, Stabner, is that?
Stabner? Yes, sir.
Okay, sorry I mispronounced it the first time. All right, you are here on a warrant for a violation of domestic injunction. I'm going to appoint Ms. Acosta in her office to represent you on this case. Another judge has already found probable cause. I will, does he have 2 cases or 1? 1. I will set your bond at $5,000. I will order you not to return to the scene and have no contact with the victim. So you got to follow your injunction, which is already no contact, and not have weapons or firearms of any kind. Is he out on bail right now?
Yes, sir.
When was that case called? It seems like it might be related to this.
No, this one, resisting officer was struck by violence.
I think that's the same date as this one.
On that same day, he was arrested on assault on law enforcement officer.
Okay, so I'm confused.
Yes.
All right. I'll take no action on the other case at this time. All right, thank you, sir.
Thank you, Your Honor.
Thank you, Your Honor.
All right, is it Rachel Wood?
Rachel Wood. President approaching, Your Honor.
All right, afternoon, ma'am, your name and date of birth, please.
Good afternoon, Rachel Wood, 10/12/87.
All right, I guess I should ask you, do you have an attorney already? You're here on a violation of probation.
I don't, but I'm kind of confused to why, because when I got sentenced, or when I took the...
Wait, 1 second, 1 second. I'm going to appoint Ms. Acosta's office to represent you.
Okay, sorry.
Talk to her first before you say anything to me.
Okay.
Yeah, she knows.
So can I talk to you now? or so-
No, after.
Okay.
Okay.
All right, so you're here for a violation of probation, so another judge has already found probable cause, issued a warrant, set your bond at no bond, so I'll stay that bond.
Your Honor, the PD was
Okay, thank you. Can I speak to you now?
on June 30th of this year, and her VOP arraignment is December 6th, 8:30 a.m., courtroom 4F.
All right, thank you.
Thank you, Your Honor.
All right, Alan Smith.
One moment, Your Honor. The defendant is in the case.
This one's also a reset from yesterday, or not a reset, but added. All right, sir, your name and date of birth, please.
Hi, my name is Alan Smith. My date of birth is 4/1/70.
All right, Mr. Smith, you're here on a case for petty theft, 2 counts for petty theft.
Yes.
All right, so another judge has already found probable cause. I'm going to appoint Ms. Acosta in her office to represent you.
Okay.
Your Honor, I believe it's 1 count.
I think
It's 1 count petty theft.
that's 1 count is,
Third or subsequent?
oh, because it's an added charge. It's an added charge from yesterday.
Yes, Your Honor.
Yeah, okay, so 1 count of petty theft, I'm sorry. Another judge has already found PC, set your bond at $500. I will, and he had the conditions of no return to Family Dollar, no contact with witnesses. So I'll keep those conditions, I'll stay that bond.
Thank you, Your Honor.
So, Your Honor, my bond is $500?
Yes, sir. I can't tell if you're excited or not.
How much is my bond, Your Honor?
$500, sir.
Thank you. That's for one?
That's for the added charge for today, yes, sir. All right. Hezekiah Anderson?
President approaching, Your Honor.
Good afternoon, Your Honor.
Good afternoon, sir. What's your name and your date of birth?
Hezekiah Anderson, February 9th, 1999.
All right, Mr. Anderson, you are here on 1 count of aggravated assault with a deadly weapon without intent to kill. I'm going to appoint Ms. Acosta in her office to represent you on this case. Ms. Acosta, I believe you had a PC challenge?
I do, Your Honor. Okay. Yes. The defense has the statute 784.021, assault with a deadly weapon, and there was no weapon found here, Your Honor.
Didn't we have 2 witnesses who said that he had a gun?
But there's no gun, and they
Uh,
actually, he
what's-
actually consent to have his car.
What's the standard for initial appearance? Isn't it just that there's probable cause for the arrest? Are you saying that 2 witnesses saying he had a gun is insufficient to establish that?
Well, Your Honor, since the officer were allowed to review his car, he consent to check his car, and there was no weapon found. My client has the opportunity to file the PC charge here without the weapon.
Okay, I'm gonna deny I'm gonna find probable cause. There's 2 witnesses.
Thank you, Your Honor.
So here's one I struggle with. You spoke to the victim, Officer Jenkins?
Yes, and the victim want contact.
Which victim was spoken to?
I didn't call, one of my other coworkers called, but she left, said that she wanted contact.
She, so it's the mother.
I think so.
All right.
I can call and find out.
Not the victim.
Who's not that's kind of the, okay. Because there's 2 people mentioned in the affidavit, that's the,
Well, it said the victim want contact and wants the defendant to return home.
right, but, so there's 2 other people who were at the home at the time, and I don't know if they were,
Is Josiah Anderson, the mother, Stephanie Anderson?
no, I understand that, I know that. What I'm saying is I think that
I talked to him. It's the brother.
I talked
I talked to the brother.
I just want to make sure you talk to the actual victim, not the mother.
Yes, I talked to the brother. It was me.
Okay. Okay. All right, I'm going to set your bond at $500 with PTR. I'm going to order you to not have any weapons of any kind. That means no guns, no knives, no, grenades, anything like that. Okay?
Your Honor, Crystal Osborne, pretrial release. In regards to the victim that was called was Josiah Anderson, who is the brother.
Okay. Good, perfect. All right, so based on Mr. Anderson, your brother, asking that you return home, I'm going to respect his wishes and allow you to return home and have contact with him. but there's to be no hostile contact. So that means you cannot even yell, you can't push, you can't scream, you certainly can't pull weapons, allegedly. Okay, do you understand those?
Yes, sir. Can I ask a question?
Oh, 1 second. I just want to finish explaining this to you. If you violate any of the conditions of release, then that's an additional charge on top of the charges you're facing. I want you to understand that, okay?
Yes, sir.
All right. Why don't, hold on. Ask your attorney a question before you ask me. Yes.
You want no hostel just with the victim or with the mother and?
I don't think the mother was a victim, so there's no hostile.
Okay, just wanna make sure.
He's okay, Your Honor.
All right, he's okay? All right, thanks.
Thank you, sir.
Thank you, Your Honor.
Thank you, sir. All right. Diego, I like that first name, Bird Natal. Good for
Person approaching? Yes, Your Honor.
your name and date of birth, sir.
Diego Bird Natal, May 8th, 1981.
I cannot tell you how much I like your first name. All right. Sir, you're here on 2 cases. The first one is for driving with a revoked or suspended license on multiple occasions. The second one has 4 counts: trafficking in fentanyl, possession of a controlled substance without a prescription, possession or use of drug paraphernalia, and possession with intent to sell, manufacture, deliver a synthetic narcotic. I'm going to appoint Ms. Acosta to represent you on both cases. On the first case, the drive-in with license suspended, I'm going to find probable cause. I'm going to set your bond at $500. On the second case, I'm going to find probable cause for all charges. On the first count, I'm going to set bond at $100,000. On the second, I'm going to set bond at $2,500. On the third, $500. And on the fourth, $50,000. On the cases that are open, I'm going to find an on-view violation of probation on both. Set bond at 0. I'm going to order you not to have any contact with any witnesses. I'm going to order you not to possess or consume any drugs or other controlled substance without a valid prescription. Okay? Thank you.
Thank you, Your Honor.
Tyrone Campbell?
Present and approaching, Your Honor.
Your Honor, what conditions for the CT?
Oh. On the last one, don't operate a motor vehicle without a valid driver's license. Thank you. Sorry. Sir, your name and date of birth.
January 8th, 1976, Tyrone Campbell.
All right, Mr. Campbell, I'm going to appoint Ms. Acosta to represent you on 1 count of driving with a license suspended or revoked. I'm going to find probable cause and set your bond at $500. I will order you not to operate a motor vehicle without a valid driver's license. Can I get a history, please?
Your Honor, only thing he had from May 22, driving while license suspended or revoked. Or revoked, 6/3/2022, driving while license revoked, and 8/22, failure to appear. And he's on 6 months probation for that, for driving while license revoked, 22 CT 1778.
Is the failure to appear, is there a warrant out for that, or that was a sentence for?
That was a sentence for.
Got it. Okay. I'm gonna find an on view.
Okay.
On the, on that case. And set no bond. Thank you, sir. Gary Coney?
Present and approaching, Your Honor.
Hello, Judge.
Hello, how are you?
All right.
What's your name and date of birth?
Gary Coney, January 22nd, 1993.
All right. You're here on 3 counts. Battery, hindering communication to a law enforcement officer, and resisting arrest without violence. I'm going to find probable cause on those charges. I am going to appoint Ms. Acosta to represent you. All right? They can't see you, just so you know. Okay. So, Would you like to be heard on conditions of release, or you're just here to observe?
I'm just here to observe.
All right. Okay. Can you raise your right hand for me? You solemnly swear or affirm testimony you're about to give in this matter be the truth, whole truth, nothing but the truth, so help you God?
Yes.
All right. Ms. Acosta, just so you know, we have, what's your name?
Brianna Brown.
We have Ms. Brown here. Ms. Brown, I have in my notes that you were requesting contact.
Yes.
Okay. Do y'all live together?
No.
Has anything like this happened before?
No.
If something like this were to happen again, would you hesitate in calling law enforcement?
No.
Okay. State?
Yes, Your Honor. Pursuant to statute, state wants to make you aware of his pending cases. He has multiple bench warrants out of Miami-Dade County for failure to appear, including 3 dwellises. He has 3 felonies open in Miami-Dade County. He has a VOP with a DUI where he is capious in Miami-Dade County. And he has a 2012 grand theft out of Pinellas County.
Any domestic violence?
I did not see any, but I'll run it one more time.
Right, well, Officer Jenkins, any history? That's what Ms.
He had battery out of Dade County, 7/2021, 12/31/2021, 4/2022.
All batteries?
Yes, sir.
Okay. All right, defense, any questions for the witness?
For the witness,
Yeah, for Ms. Brown?
is she the wife of Mr.?
No, just a girlfriend.
You don't have any problem with he come back to the house? He's coming back?
No.
I don't have any further question, Your Honor.
Okay. So I appreciate you being here. Ultimately, I have to, on the law, when the statute says I got to protect the public, including the victim. Given the history that he's had 4 other batteries this year, I'm going to order no contact with you. Okay? I understand you disagree with it, and I understand you asked for contact. We'll make that clear for the record, that you asked for contact, but I'm going to order no contact based on the history, okay?
Okay.
I'm going to order Mr. Coney to not possess any weapons of any kind and to not return to the scene, except he'll be allowed to go back one time with law enforcement to get his stuff. Okay? All right. Thank you.
Thank you, Your Honor.
Thank you, Ms. Brown.
Your Honor, did you get the bonds on those 3
Oh, did I?
charges?
No, $1,000, $2,500, $250.
1,250 and.
$250, yeah. This is why you guys are here. Eduardo Figueroa Rivera.
Afternoon, sir.
How are you?
Okay.
Given the circumstances, I understand that.
Yeah.
Just give us 1 second.
Yes, sir.
This has been tempting me the whole time. We're just getting the witnesses. They're outside, so.
Okay.
But we can go on with the boring stuff. What's your name and date of birth?
March 22nd, 1991.
And your name?
Eduardo Figueroa.
All right, Mr. Figueroa, you are here on 2 counts. 1 is battery. Other one is child abuse without great bodily harm. I'm going to appoint Ms. Acosta and her office to represent you on this case.
I do have a probable cause argument for.
All right, let's hear it.
Right. Yes, based on the affidavit, Your Honor, there's no injury on the child. As the statute requires, there's not any evidence of injury on the child. And actually, there was a witness there. Well, when the officer asked him if there was any evidence of the child being hit, the witness answered no.
Is that what it said? I thought they said if he saw anything, and he said no.
Right, yes, Your Honor.
Ms. Kleinpeter, you want to address there's no injuries or injuries required?
Standard child abuse does not require injuries. It's without great bodily harm. According to the affidavit, he took the child out, dragged him by his feet out of the car. There's no parental corporal punishment that can be justified there. But child abuse by itself does not require physical injury. If this were charged as child abuse GBH, yes, it would, but that does not require an injury. It just requires that violence is committed on a child that cannot be justified by corporal punishment. Dragging a small child out of a car by his feet does not meet corporal punishment. It alone would be.
Statute defines child abuse in 3 ways. Intentional infliction of, and I'm going to skip the mental part, physical or mental injury upon a child. So we don't have proof of injury. But under number 2, an intentional act that could reasonably be expected to result in physical or mental injury to a child. Under that, I'm going to say it meets the definition of child abuse. So I'll find probable cause for the arrest based off of that. So I'll find probable cause for both charges. Hi. So they can't see you, just so you know. Camera faces me. Unfortunate for them. Can you raise your right hand for me, please? Do you want to tell me something? Do you put your hand up? Do you want to tell me something? Or are you just here to observe?
Just to observe.
Okay.
Because I was going to suggest, but I understand that I can't suggest.
So it sounds like you do want to tell me something. So raise your right hand. You solemnly swear or affirm testimony you're about to give in this matter to be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
All right. What's your name, ma'am?
Gabriela Cuellar.
What's the last name? I'm sorry.
Cuellar, Cuellar.
Okay, Cuellar. All right, ma'am. And you are here, you're listed as the victim in this case?
Yes.
All right. You wanted to tell me something?
I just wanted to suggest for the other charges for the domestic, if there's any way that he would have to do counseling. That's something, I know that's up to you, Your Honor, but that was something I just wanted to suggest.
So today is just to find if there was probable cause for the arrest and then conditions of his release.
Okay.
Those are the only 2 things that we determine today. We don't determine any punishment. We don't determine any guilt or innocence. We don't determine anything like that. It's just, did they have a reason to arrest him? Was there enough probable cause to arrest him, which I've already found there was. And then the second one is, what are the conditions of release?
Okay.
I see here that you said you wanted contact.
Yeah.
All right. Has anything like this happened before?
Previously, it's happened before, but not physical.
Okay.
Verbally.
So I'm a little bit worried. I'm going to tell you why. Because you just said you want him to have counseling. Usually, in my experience, and I do domestic violence injunctions, I do a bunch of them, people only request counseling if it's something that's happened a bunch or they think the person has a problem that might happen again. If something like this were to happen again, would you hesitate in calling police?
No.
Okay. State?
Your Honor, there's no, I see no significant criminal history in the state of Florida. But given the circumstances, given some of the admissions of the defendant that he did smash the window, showing pure anger in front of his child and the mother of his child, state argues no contact until this matter is resolved, both for the safety of the child and the safety.
Is this his child?
The father is deceased.
Sorry, I didn't mean to cut you off, Ms. Kleinpeter.
Oh, it's fine, Your Honor. Due to the safety of the child and safety of the mother, that state would be requesting no contact based on the defendant's own actions. The fact the victim has admitted that this isn't a first-time offense. Again, state would object to a no hostile. State would request maintain separate residences, no contact, may return one time with Leo. Other than that, bond as Your Honor sees fit.
Okay, Ms. Acosta?
Yes, Your Honor, the alleged victim already says that.
Oh, do you have any questions for her first?
Yes, sir.
Not you. You can't talk. He talks a lot.
No, Your Honor, I don't have any question for her.
Okay. Now, what would you like to say? I'm sorry.
I just want to say that she already said that she wanted contact with my client, and then there was only verbal discussion that they have in the past. There was nothing physical, and neither her nor her child have any actually injury right in this moment, and then she's already there by herself saying that she wanted contact with my client, so I see no reason why not to have him contact with her.
I don't like the dynamic here. I'm gonna be honest with you. I don't like the dynamic. So part of I understand you're asking for contact. Part of my job is to set conditions that protect the community, especially the victim. Okay? So I'm gonna say no contact with you. Okay? So he's gonna maintain a separate residence. He can't come to the home except for one time with law enforcement to retrieve personal belongings. You can have no weapons, sir. Okay? So no weapons, no guns, no knives, no anything. You're not to contact her. So you can't contact Ms. Cuellar. Can't call her, can't email her, can't text her, can't slide into her DMs, anything like that. Do you understand that?
Yes, sir.
All right. And I'm going to set bond on the battery at 1,000, on the child abuse at 1,000. The total monetary bond will be 2,000. Those conditions on both accounts. All right. Okay, thank you, ma'am.
Yep.
Thank you, Your Honor.
Thank you. Floyd Harvell.
President approaching.
Good afternoon, Your Honor.
Afternoon, how are you?
I'm all right.
What's your name and your date of birth?
Floyd Darrell Harvell, 6/24/88.
All right, so Mr. Harvell, you are here on two cases. First one is possession of a weapon of ammo by a convicted felon, carrying a concealed firearm, and possession of marijuana. The second case is a possession of a controlled substance without a prescription and bringing a controlled substance into a county facility. I'm going to appoint Ms. Acosta to represent you on both cases, okay?
Yes, sir.
All right, so I'm going to find probable cause for both cases. History.
From 2017, he have no valid driving license, weapon offense, possession of weapon, drug possession, all this out of Orange County, failure to appear out of Orange County. Failure to appear like 4 times out of Orange County, out of Connecticut, 2004 robbery.
How many times out of Orange County?
I heard
4.
4.
Your Honor, I also have a 2007 carjacking, aggravated assault with a deadly weapon, 2005 robbery with a firearm ×2.
Okay. So I'm going to set your bond as follows. On count 1, the possession, I'm going to set it at 10,000. On count 2, the carrying of concealed, 1,000. Count 3, possession of marijuana, 250. On the second case, I'm going to stay the bonds at 2,500 each. I'm going to order you not to possess any weapons. Okay?
Yes, sir. No problem. I wasn't supposed to have one.
I understand it's tough out there, but you can't have a weapon, okay? And then not to possess any controlled substance or drugs without a valid prescription, okay?
Yes, sir.
Your Honor, do you want the do not possess any weapons or firearms on the first case?
Yeah, on the weapons case.
And then the.
Just put it on both.
Okay.
Yeah, makes it easier. All right, thank you, sir.
Thank you, Your Honor.
All right, Jalen Hatcher.
President approaching.
Family member or friend, not a victim.
Okay.
Mom?
You want to come up? All right, sir, your name and date of birth.
Jalen Hatcher, June 18th, 2003.
All right, Mr. Hatcher, you are here on 3 different cases. 2 new cases and then 1 warrant, okay? The first case, you have a battery count. The second case, you have an obstructing an officer without violence count. On the third case, the warrant case, you have 2 counts. One is burglary of an auto unoccupied, and the second one is petty theft from the vehicle. I'm going to appoint Ms. Acosta to represent you in all 3 of those cases. Okay. On the battery count, I am going to find probable cause. On the obstructing an officer without violence, I will find probable cause. A judge has already found probable cause on the third case, the burglary with the petty theft. Your mom? All right.
Yes.
Hi,
Hi.
how are you?
I'm okay.
Is there something you want to tell me, or you're just here to watch?
Just here to watch.
Okay. All right, well, welcome. All right. Your mom is here, just in case you couldn't hear. Okay.
Yes, sir.
All right. You're 19, right?
Yes, sir.
I have that the victim is the same person in all 3 of these cases.
Other than the resisting without, yes, Your Honor.
Right, other than the resisting. Any other history for him?
The only history he was, I think he was a juvenile then, 2020, possession of firearm by minor.
Okay.
And that probation ended, it was recently ended, Your Honor.
You nice kid?
It was ended 12/2/2021, Your Honor.
Is he a nice kid?
I'm sorry.
Is he a nice kid?
He is a nice kid.
He lives with you?
Yes.
Right. Anybody else live there?
My daughter.
Does he work? Does he go to school? What's he do?
He's supposed to be getting his GED, and he's working.
All right, Mr. Hatcher, on the battery, he qualifies for PTR with bond
Yes, sir.
on all cases?
Yes, sir.
I'm gonna set your bond on the battery at $100 with PTR. The same on the obstructing. On the third case, the judge had set your bond at $3,500 for count 1, $500 for count 2. I will stay those bonds. I'm gonna, no, just straight bond. I will order you not to have any contact with the victims. So you can't have contact with her, okay? You can't go to her house. You can't come within 500 feet of her house. Do you understand that?
Yes, sir.
All right. So I'm going to tell you her name, which I'm sure you know. That's Jonelli De Jesus Amador, right? So you can't have any contact with her. Can't come within 500 feet of her home. You understand?
Yes, sir.
All right. You cannot possess any weapons of any kind. And that'll be it. That'll be it.
Thank you, Your Honor.
Thank you, sir.
Thank you.
Thank you, ma'am.
Thank you.
Sean McCray.
One moment, Your Honor. Your Honor, I want to waive the reading of the charges.
All right.
Your Honor, for the Mr. Hatcher, the obstruct officer with violence, is it on with PTR? It's just the last case that's no PTR.
Is it? Right.
Okay, just wanted to
Yeah.
thank you.
So it's 100 with PTR, 100 with PTR, and then the straight bond, yeah. All right, name and date of birth, sir?
Sean McCray, January 10th, 1979.
All right, Mr. McCray, you're here on 2 counts. I'm going to appoint Ms. Acosta to represent you on those. I'm going to find probable cause for both those counts. Count 1, set your bond at $5,000. Count 2, $500. I'm going to order you not to have any contact with the victim and not to return to the scene. Additionally, I'm going to order you to not have any weapons. He is out on 2 cases right now.
Yes, sir.
All right, so I'm going to revoke on both cases, set bond at 0. All right. Thank you, sir.
Thank you, Your Honor.
Did you give a bond on the, this case?
5,500.
Okay.
All right, Kelsey Ola.
President approaching, Your Honor.
Afternoon, your name and date of birth.
Good afternoon, Your Honor. Kelsiola, 3/3/2000.
All right, Miss Ola, you're here on one count of battery. I'm going to appoint Ms. Acosta and her office to represent you on this case. I'm going to find probable cause for that charge. I'm going to set a bond for you. Any history for her?
No Florida history. She have history out of Michigan, assault, fraud. She was on 12-month probation, which she completed, 2018, obstruct police, where she was found guilty, 2018. Escape flight, that was dropped, 2021, assault, domestic violence.
Same victim? Does it say?
We don't know because it's in Michigan.
Oh. I'm going to set your bond at $250 with PTR. I understand it says victim wants contact, just given the history of a prior domestic violence incident. I'm going to order no contact. I'll allow a one-time return with law enforcement to retrieve personal belongings. All right, maintain separate residence, I think goes along with the no contact, but. All right, thank you, ma'am.
Thank you, Your Honor.
Daniel Rosario Rivera.
President approaching, Your Honor.
Sir, name and date of birth.
Daniel Rosario, 10/25/2004.
All right, you're here on 2 counts. One is aggravated assault on a law enforcement officer. Second one is resisting an officer with violence. I'm going to find probable cause for both those charges. I am going to appoint Ms. Acosta and her office to represent you. I will set your bond at $5,000 on count 1, $1,000 on count 2. I'm going to order you not to have any contact with the victims other than a professional setting, I suppose. And not to possess any weapons of any kind. Thank you, sir.
Thank you, Your Honor.
Kevin Hairston.
President approaching.
All right, name and date of birth, sir?
Kevin Hairston, 5/17/1988.
All right, Mr. Hairston, you are here for a warrant case. So another judge has already found probable cause. I'll appoint Ms. Acosta and her office to represent you. There's 2 counts on that warrant. The first one is grand theft. The second one is obtaining property under $20,000.
We had this yesterday. Is this the same one from yesterday?
I'm sorry, the affidavit has 2 counts, but the information filed by state, they only are charging him with the grand theft.
Okay,
Which is why
so,
we had to re-IA him.
okay, good news. I got good news for you
Just
today.
to confirm.
Second count is gone, so it's only the first count.
Which count?
That's the grand theft, right?
Grand theft is the one he's being charged with, the second count, is not being.
So your bond went down from yesterday to today.
So I only have 1 count now?
Yes, sir.
All right, thank you, sir.
And then we'll keep everything the same.
Saying that at 2,500.
Yeah. And then we'll keep everything else the same as yesterday, all the conditions, which I don't remember.
And what was the
How
bond
much
for
is
the
the
first
bond,
count?
Your Honor?
It's 2,500.
Okay, yes, sir.
Yep. Sorry about that confusion.
That's all right.
You know, it happens. I don't read everything, you know how it goes. Yeah. All right, thank you, sir.
Thank you, Your Honor.
Ashley Yarborough.
President approaching, Your Honor.
Name and date of birth, ma'am?
Ashley Yarborough, June 16th, 1993, Your Honor.
All right, Miss Yarborough, you're here on 1 count of possession or use of drug paraphernalia. I'm going to appoint Ms. Acosta and her office to represent you. I'll find probable cause for that charge. And I will History?
2016 drug equipment possession, possession of cocaine, driving with expired license, out-of-state fugitive, drug equipment possession, possession of cocaine, 2020 aggravated battery, 2021 burglary with assault, out-of-state fugitive, out-of-state warrant, 2022 failure to appear in Bay County, failure to appear again,
There's 2 failure to appear? And then the fugitive warrant?
3 failures to appear out of Polk County.
All right.
She had
I'm
open
gonna
case.
set your bond at $1,000.
Okay.
Order you not to control or possess or consume any drugs or other controlled substance without a valid prescription.